the difficulty is that this has been pending for quite a long time, and we have a direction from the Honorable Supreme Court of India that has requested this Honorable Court to dispose of this case expeditiously. And that order was passed way back in September of last year, Your Lordship.
See, basically when the matters are listed, councils from Manipur not appeared, right?
Yes.
So
We have been appearing with that.
we know very well. Which item you're talking about?
Item number 12, Your Lordship.
Matter relates to bench two, not here.
Not this matter.
That's why we're asking for. This is altogether different bench. Do one thing.
Mirror.
No, he can what? This was not, this is the next step. This is not.
Oh, I apologize for that.
Do one thing.
Yes, sir.
That bench will not sit today. Whenever that bench will sit, you make a mention and fix it in.
Very well. Oblige, Your Lordship.
Inform the other side also, so that a date can be fixed.
Oblige.
Page 42, this is 70 voter list.
Then number two,
42, page 42, 1970 voter list. It is also village superivita. 66 voter list, that was also village 66.
your
60.
second ground is what? For review?
No, that is I am telling well. First, Lordship would see the NRC details that is
Please
of
come to
village
your-
superivita.
Mr. Mahmood, please come to the grounds for review.
40, page 40. These are
Grounds
grounds.
for review.
Yes, grounds for review that. Page 9,
Number one is 1966.
60 voter list is not considered. Only consideration is not enough. It should be considered in accordance with law, my lord.
Okay.
So then, my lord, they order,
Consideration as per law, you are copying.
yes,
Okay.
it should be
And-
considered as per law.
Second ground,
Second ground, my lord, delay point has been taken.
Hmm.
But delay point cannot be a ground to declare a person a foreigner. Because delay does not extinguish a right of a man or woman. Then Lordship would say, page 11, Roman 3.
Hmm.
For that, it is also important to take into account the observations made by the Honorable Supreme Court in the case of Sunil Kumar Roy and others versus the state of Bihar and others, wherein the Honorable Supreme Court by its order dated so-and-so had made the following observations, paragraph 9. But even assuming for a moment that the petitioners have come with some delay, we find reassurance from the opinion of this court in the judgment reported in Asan Sonnilito Mahasangha and others versus Union of India and others, 2015 3 SCC 1, wherein this court has entirely held as follows. Further, in Olga Tellis versus Bombay Municipal Corporation, it has now been conclusively held that all the fundamental rights cannot be waived at para 20, and given these important developments in law, the time has come for this court to say that at least when it comes to violations of the fundamental right to life and personal liberty, delay or laches by itself without more would not be sufficient to shut the doors of the court on any petitioner. So, my lord, delay, the legal door of the petitioner should not be shut down.
okay.
Then Lordship would say, that is what regarding delay. Then Lordship would say, page 12, paragraph 4, Roman 4. That meanwhile, there have been subsequent developments in favor of the petitioner as her own name, as well as the names of her siblings and children have been recorded in the final NRC. They are as follows. The names of the petitioner's 5 brothers, namely Nasimuddin, Sohrab Ali, Nur Muhammad, Zahirul Islam, Abul Hussein, and Hashem Ali have been recorded in the final NRC 2018. Then the name of petitioner's son, namely Samad Ali, have been also recorded. Then, my lord, the name of the another son, Joydar Ali, has been also recorded in the final NRC by ARN number 7. The number has been also given, madam. So those copies have been annexed in this review petition as annexures H, I, J, K, L, and M respectively. Then, Lordship may kindly come to page 13. Para Roman 5. In large number of judgments, the Honorable Appeals Court has also held that courts have ample powers to review its own orders, even on subsequent developments. The Honorable Supreme Court has also, in a number of cases, has asserted that by taking into consideration that if the names of the petitioner's parents, brothers, or children have been listed in the final NRC, it would be a good ground to presume that the petitioner is also a citizen of India.
Good. Okay.
So, some copies of the order of the Honorable Supreme Court I have annexed, wherein Lordship, we have marked those orders P, annexures P, Q, and R. Here, the value of the listing or recording the names of the siblings, nearest relatives, if recorded in the NRC, that has been given adequate value by the Honorable Supreme Court, which has also the support of Abdul Quddus case, para 28 and 29.
These are the grounds on the basis of which
Yes,
we have.
these are the other grounds, my lord, we have made category statement that at the time of submission, that may be said. Now, Lordship, I
Just
invite
tell
you.
us one thing, whether the names of your siblings.
Yes.
And your sons
Yes,
been published
yes,
in the NRC
Yeah.
of 2018, right?
Yeah.
Now, is it the final NRC published?
not yet published, but thing is this,
It's
my
a
lord.
draft NRC.
My lord, draft, yes, my lord, that has been done
That's
after
why we're
the,
asking you whether final NRC has been
no,
published.
that is not done, but
What is the law with regard to the names published in the NRC?
the
What
law
is the
is, my lord, law is a dynamic subject. Earlier, as per
Tell
section,
us what is the law settled by?
I am
this court?
saying, I am submitting that. As per sections 15 of the NRC Act, the NRC is not the proof of citizenship. But as per order of the Honorable Supreme Court, it is said that if a person's name has been enlisted in NRC, that is a good ground that he is also a citizen of India. Because though the final NRC has not yet been published, but what are published, those have been published on the basis of day-to-day house visiting by enumerators.
I don't think so. When you, for NRC, anybody has a house enumeration, it was an online process only. And subject to go to the Seva Kendra, you have to submit, deposit all the documents.
No, that was last, during the time of further examination. But first time, the enumerator visited the house to house.
Which year?
It started perhaps from the year 2016 perhaps. They earlier visited the houses and then prepared the list, and finally the persons were asked to bring those original documents, and they came, and after being satisfied, the officers, though it is a draft list, but it should not be rejected at once, madam, because after all, those drafts have been also made by public officers after house to house enumeration.
Whether your husband
Madam.
has been proved to be a foreigner, or was there any foreigner?
There is no case against my husband, nor against my father.
Your projected father.
My lord,
Your projected father.
Yes, there is no case against my father and nor against my husband. And my lord, there is one reason which may be for in the same village, another joyfulness is there. And his name, there is the letter D. And fortunately or unfortunately, my lord, her name is Joyfulness. Husband's name is Rafiq Ali, I think. Father's name is Jamshar Ali. Here, the husband's name is I think Rafiq Ali. Your husband's name is Shamsul Haq. And that very girl, his name may be seen, my lord. I am showing your lordship. That was perhaps one of the reasons for which I was doubted about my citizenship. That is Shamsul Haq. That is page, kindly see page 53, my lord. Here is the name of Shamsul Haq and Shakiruddin. Joyful Nasa husband Shamsul Haq. Village, Rashibutsi village, Supari Vita. And this is from electronically, this has been obtained. Now, Rashibutsi, page 59. Shamsul is serial number 769. Here, Shamsul Haq, son of Shakiruddin, Joyful Nasa, Shamsul Haq. Village name is Suparivita. So here, Lashibutsi, page 60. This is the certificate of local Gaura. Joyful Nasa, daughter of Jamshar Ali, village Suparivita, post office Tulsibari, PS Lakhipur, district Gwalpara, Assam. She is an inhabitant of the said village in the jurisdiction of Tarangapur, Gaon Panchayat. Her father's name has been enrolled in the copy of NRC in 1951. Right, serial number so and so, village so and so, PS Lakhipur, whose name was Muhammad Jamshar Ali, son of Basiruddin. My grandfather is Basiruddin. So, this has been issued by the Gaura, quoting the serial number. Gaura is not authorized to issue such certificate, but he is only telling that she is known to me and she is a resident of so-and-so, daughter of so-and-so. And lastly, he says, Joyful Nasa is the daughter of said person known to me. She has been married with Shamsul Haq. So here, serial number of the village has been given. Now, Lashibutsi, reason of doubt is page 61. Kindly see. Joyful Nasa D. Page 61, Joyful Nasa, wife of Shamsul Haq. Here, Shamsul Haq's father is Muhammad Ali. And my father-in-law's name is Shakiruddin. But in my name, against my name, there is no letter D. Kindly see verse 45. This is very important point. Page 45, Joyful Khatun, wife of Shamsul Haq, and Shamsul Haq, son of Shakir, or Shakiruddin. Here, Lordship, kindly see page 61. Here, Shamsul Haq, son of Muhammad Ali. Joyful Nasa, wife of Shamsul. Husband name is same, But here, this Joyful Nesa's father-in-law's name is Muhammad Ali, not Shakiruddin. And against her name, there is letter D. So there was some wrong identification, and wrong person has been given the certificate, given the notice from the tribunal. So this is our case from the very beginning, not only in High Court. Similarly, also Honorable Lordship will also see that Joyful Nesa, page 63, kindly see. Joyful Nesa, husband name Shamsul Haq, letter D. So, in against my name, there is no letter D. We tried our level best to make it understand to the Honorable High Court, but High Court did not take the matter for consideration. That in the same village, there is another Joyful Nesa whose husband is Shamsul Haq, and my husband's name is Shamsul Haq. But difference is this: my father-in-law's name is Shakiruddin, and that Joyful Nesa's father-in-law's name is Muhammad Ali. So we tried our level best to make understand this, but nobody was seriously trying that whether even SP may be directed that whether I am that Joyful Nesa against whose name there is D or not. No inquiry is made. Very casually, order has been passed, though this is a matter of citizenship. So these are the things which request to be thoroughly examined, though in the review jurisdiction. So firstly, I citation. Now, Lordship may kindly say some observation of the learned tribunal, page 68, kindly see.
Just a minute. Please take your seat, Mr. Mohammed. Yes, which page?
Regarding the order of the learned tribunal
Hmm.
that I was discussing.
Which page?
Mm. Where I can- is 68.
Hmm.
Second para.
Hmm.
On perusal of record, it appears to me that the respondent furnished the following documents with written statement by a Firisti, a photostat copy of 1966 voter list, but in respect of whom that was not stated. So, my lord, this is very improbable thing. I have submitted a copy and there is the name. In respect in Firisti, details are not written. Learned tribunal should have known that in Firisti, details are not written. Firistis are only a list of documents which are submitted. And those are duly explained when the evidences are reduced. Those are marked as exhibits and as may be proved as in view of section 67 of Evidence Act. So it is very peculiar that in respect of whom that was not stated. The document itself will speak. B, photocopy of Panchayat certificate which is not in accordance with the clause 13 of column 14 of format mean for report of LVO available with the record. Here, my lord, my submission is this. The learned tribunal has given more value on LVO's report. LVO's report is only for the purpose of starting a proceeding.
Hmm.
That is not the conclusive proof. So, how the learned court can believe or can entrust fully that it is not in accordance with clause 13 of column 14 of format meant for report of LVO available with the records. So that is not in LVO's report, that is only for starting a proceeding only, not more than that. Page 68. Now see extract photocopy of 97 voter list, extract photocopy of voter list 2007, which is not at all necessary, but after perusal of the extra copy of 1997 and 2007, Panchayat voter list, it appears to me that in 19 voter list at serial number 522 against house number 171 of 27 Suparivita village, D is not seen against the name of respondent. And in the like manner, in 2007, Panchayat voter list photocopy in serial number 68 against house number 171 of Suparivita village, D is not given against the name of respondent. So, in my opinion, this is the reason as to why after submission of WS, the respondent did not turn up. Yes, that is correct. Because D was not against my name. Then Lordship would say, let us see the case of respondent in her WS. The answering respondent denied to be an illegal migrant either from East Pakistan or from Bangladesh. Answering respondent stated that she is citizen of India by birth and she was born at Supari Vita village about 40 years ago. Her father was Jamshar Ali, who was a citizen of India, having his name enrolled in 1966 voter list at serial number 139 against house number 44 of village Supari Vita. She got married with Shamsul Haq, son of late Shokiruddin of same village. The respondent wrongly alleged that till 2005, the respondent casted her vote and her name was recorded in the 1997 and 2007 voter list. It is not correct, my lord. I have annexed those voter lists, at least some of the voter list. Actually, my lord, voter list of before 71 is necessary, but thereafter, some additional voter lists, normally we annex to show that not only after 66, but thereafter also, my physical presence is in the soil of India or Assam. So that is the reason we have annexed certain other documents. Now, Lordship would say, the respondent has wrongly alleged that till 2005, the respondent casted her vote and her name was recorded in 1997-2007 voter list. So, Lordship may kindly see now page 48, my lord. 48. Here, Joyful Nessa, name is in the voter list of 1989, the wife of Shamsul Haq, and Shamsul's name, father's name is related as Shokiruddin. Then it is 97 voter list, Joyful Nessa is there, and husband Shamsul, and father-in-law Shakir. So, Learned Tribunal is saying that the respondent wrongly alleged that till 2005, the respondent casted her vote. Her name was recorded 1997 and 2007 voter list. Now 1997 voter list, page 50, and thereafter another voter list 2007. That it is 2005. It is 2000. The tribunal said that from 2005. Here, Lordship would say, in 2005 also, her name is there, page 53, bottom. So it is not the finding of the Learned Tribunal that wrongly, it is not wrong. It is in voter list. Now, if any doubt, the other side may raise any doubt, then they may verify. They have agencies. So the Lordship would say, of course, here is a one defect, my lord, I will admit humbly, that from the record, we do not see that he has adduced more witness. So that is perhaps was due to wrong advice, or Lordship here in another case, Momana Khatun's case, she said item 5, she said that the tribunal said me that your case would be considered on the basis of document, you have good document. So accepting her, no other evidences were adduced. Here in this case, Lordship, there was an expert order, so he filed a petition that on 14/3/2016, that is page annexer 15 of the writ petition, but that was rejected. Annexer 15, let me show the annexer 15 before your Lordship can very well. That is page 74. Page 74. Page 74, she filed a petition that I have so many documents. So expert order may be vacated and I may be given a chance to prove my
Yes,
case.
Mr. Pai. Say,
Well,
petitioner
my
was
last
found to be-
point,
we'll
Lordship.
come back to you. We'll get, after you reply to Mr. Payang and Mr. Ali, whoever appeared.
Now, my only prayer would be, my lord, I am not that joyfulness. Sir.
You understood?
So why they do not inquire? What is the harm with them?
Okay.
Inquire whether I am that joyfulness at D or not.
Yes.
They do not say, they say here and there, but real thing they avoid purposefully or may not be in good sense.
Now, you have heard Mr. Mam.
Yes,
See, cases like this, the petitioner received a notice.
Yes.
From the furnace trial. She appeared and filed her written statement. The FT case was 1220/G/06. After filing her written statement, she did not appear.
she did.
So the
Expert.
concerned lawyer was representing the petitioner surrendered because she stopped connecting him, no information. So he withdrew from the case. Then the court, after giving 4 days to adduce evidence, passed an ex parte order on 14th of July 2009. Thereafter, the petitioner
Proceeding.
preferred the writ petition, WPC number 657/2016.
16.
It was filed in 2016 against the order of 14th of July 2011. That she said that she came to know that very late.
Yes, yes,
In fact, by the time the draft
Yes.
NRC was there, her name did not figure. That writ petition was dismissed by coordinate bench of this court on 11th of February 2016.
16.
Thereafter, in March 2016, petitioner again
Filed a review.
filed an application under Order 9, Rule 13 to vacate the ex parte order. The said order was the said application, that is the case
Review.
number 42/26 of 39, that which case number filed in the dispose of FT case, was dismissed on 15th of March 2006.
Yes.
Thereafter, petitioner filed another writ petition on 18th of July 2018.
2018.
Now, to set aside both the ex parte order of the tribunal as the letter of 14th of July 2009, that was already decided by coordinate bench of this court, as well as the order dismissing her application under Order 9, Rule 13, that order of 15th of March 2016. So that writ petition of 2018 of the petitioner was dismissed on 30th of July 2018.
2018.
Against that, the petitioner
Preferred
approached the Honorable Apex Court, filed a special leave to appeal, and which was dismissed on merit
Yes, on merit,
on
merit.
10th of December 2018. Thereafter, petitioner on 17th of June 2022 filed this review petition. This is the background. Now tell us,
Well, first of all, my lord, my submission will be this review petition is not maintainable at this stage. My lord, my first submission will be that is, this is not maintainable at all. First of all, for that, my lord, as your lordship has given the history of the entire case, my lord.
not history, background of the
Yes, background of the entire case, my lord. 2009, the my lord, tribunal given an opinion. Then she approached before this honorable court. This honorable court, by filing a writ petition that was dismissed in 2016. She approached after 4 years, my lord. Initially, she approached after 4 years, and for that reason itself, this writ petition, that writ petition was dismissed.
No,
Again-
she
Yes.
approached this court after 7 years.
After 7 years, sorry, ma'am. After 7 years, yes.
6.5.
After almost 7 years. Then, without the order of this honorable court, my lord, she approached the tribunal. Tribunal cannot pass order. As this the writ petition was dismissed by this honorable court, tribunal definitely, my lord, tribunal dismissed that review. Again, that she filed another writ petition, my lord. In fact, which was not maintainable at all. My lord, that writ petition was also dismissed, saying that as you have approached this honorable court earlier, so we cannot entertain this writ petition. So that was dismissed. Again, my lord, that was challenged in the Honorable Apex Court. Apex Court said there is no merit. So the SLP was dismissed by the Honorable Apex Court in 2018. Now, against the order dated, my lord, 15/3/2016 and my lord, 37/2018, she is approaching before this Honorable Court. But she is not, my lord, asking review of the order dated 15/3/2016. Even though this is reviewed, my lord, the 15/3/2016 order will remain. That is not interfered by anyone. 15/3/2016 passed in WPC number 11/2016. Sorry, my lord, 11/2016 order passed in WPC number 657/2016 is not under review. It is not read for review, my. So now, my lord, after 2018, the Honorable Apex Court had dismissed the SLP on 10/12/2018. He has approached this Honorable Court after 4 years. That is on 17/7/2022. After 4 years, without giving a single explanation as to why he did not file the review petition at that time, man. 4 years, there is not a single whisper why this review petition has been filed after 4 years. Is it a mockery of judiciary, man? They have abused the process of law, entire process of law, man. They are filing cases after cases after cases. In my first submission, my lord, my submission will be this review petition is likely to be dismissed with all cost, my lord. This is enough, is enough. This cannot be allowed, my lord. Same process. And what my learned senior friend is arguing the writ petition. This is review petition. All these arguments were taken at the time of review petition in both occasions, my lord. These were dismissed. Those were negated by this honorable court. They are arguing the same point. It is not the writ petition. This cannot be allowed, my lord.
Okay. Then,
My lord, secondly, my lord, my learned senior friend is arguing, I'm again pointing out that point, my lord. He is arguing that, my lord, that he is not that person. She is not that person.
wrongly identified.
Wrongly identified. These points were taken in the writ petition, both the occasions, my lord. It is in the order itself. And her name is not marked as the, that is also taken care of by this honorable court at the time of writ petition, my lord. Where is the point of, my lord, review in that case? Because those points were taken care of by this honorable court. earlier. So he want to reopen the writ petition by way of this review petition, which is not permissible as per law. What are the grounds, my lord? Even, my lord, this, what are the grounds taken? Next point, my lord, what are the grounds taken? First ground is that, my lord, may I read the grounds, my lord? First grounds. What if the Honorable Court has not considered the various documents such as voter list of 1966 in proper perspective, where the name of the petitioner's father, Jamshed Ali, Gaon Panchayat certificate issued in the name of petitioner, which clearly established her linkage with Jamshed Ali. Has she given any evidence? She has not given any evidence of all these documents. She simply filed the WS and flew away, my lord. She did not contest. She did not file any evidence. Is it the duty of the tribunal to presume everything, that all these contents of the document is correct? It is their duty. Burden is casted on them. Why did he not prove those documents? Why did he not give any explanation? He is my father, he is mother. It is not the duty of the tribunal to examine, to presume that yes, this person may be the brother, person may be the father, this person may be the mother.
No. Just a minute.
The second point they argued, the second grounds they have taken is the order passed by this Honorable Court and order passed on the ground of inordinate delays in approaching this Honorable Court is that is matter of silence. They can go to the apex court. Why did he not go? They can go to the apex court, my lord. This Honorable Court cannot, under review jurisdiction, can say, my lord, the coordinate bench has committed error of law, or this point is, my lord, is to be reviewed. This is not under the review jurisdiction. If this is, my lord, yes, this point the tribunal, this Honorable Court has decided wrong law, my lord, then they can definitely approach the Honorable Apex Court. And what is the explanation? This Honorable Court has clearly considered, not in all cases, my lord. In this case, it is considered why it is, my lord, the delay is not accepted. After consideration, only the orders were passed, both the orders. And third ground taken, my lord, for that it is also important to take account of observation made by the Honorable Supreme Court in Sunil Kumar Rai versus So-and-so. The Honorable Court had made the following observation: that, my lord, the fundamental right and personal liberty of the person should not be, my lord, as per this judgment. This is under Article 32. Further, in So-and-so versus So-and-so, given this important development in law, the time has come to this court to say that at least when it comes to the violation of fundamental right to life and personal liberty, delay or laches by itself without more would not be sufficient to shut the doors of the court on any petitioner. They can, my lord, they can definitely approach the Honorable Apex Court. If Honorable, this is under, my lord, Article 32, Honorable Apex Court has considered some cases.
Please take it. Yes, I will have the 5.65. Excited on you. Technically, we have orders. I put on it. I'm excited on you. Oh, yes. Market time, right? About the Hello. Yes, please proceed.
My lord, then the fourth and fifth ground is the same ground, my lord. They have taken a ground that, my lord, some subsequent, my lord, development has taken place because the NRC, draft NRC has been published, where the siblings of the petitioner, in fact, she has said, my lord, her name is appearing in the, my lord, NRC, but she has not stated how it is appearing. But she has said that, my lord, the siblings of the petitioner and son and daughters of the petitioners are
Just tell us one more thing.
Yes.
After the dismissing of the special leave to appeal by the Honorable Apex Court on the ground of merit,
Yes,
can you go for review?
no, my lord. He cannot go for review. I'll come to that point, my lord. But what is the grounds they have taken? I'm just reading out that, my lord.
These are subsequent
These are
matters.
subsequent.
They need
Yes.
these family members,
In fact, my lord,
sons, and have been declared to be name figured in the voter list.
Yes.
Name figured in the NRC.
it may figure, my lord, but the law says, my lord, it is settled position of law. If the person name is declared foreigner, if a person is declared foreigner, or is under, my lord, his case is pending or her case is pending, his name should not figure in the NRC. That is the settled position of law. So what if for whatever reason her name is appearing in the, my lord, NRC, that is illegal. That is absolutely illegal because it is against the provision of law. Law has said that. So her name cannot appear in this. Even though appears, my lord, that cannot be ground of, my lord, review or review. And secondly, my lord, even though the brothers' names may appear, or son and daughter's name may appear, my lord, because against father there may not be any, my lord, proceeding, and against brother and sisters there may not be any proceeding. But she has to prove that those are my brothers. Until she proves those are my brothers, how can she claim the benefit of those persons, my lord? So every case, my lord, that's why I always submit. If he says, my brother is declared Indian, my sister is declared Indian, why should I be made foreigner? That is not the case here, my lord. Each and everyone has to prove their own case by linking their father or grandfather. That is this case, my lord. She has to prove her own case. Yes, I'm the daughter of that person and sister of those persons. Once she proves that I'm the sister of those persons, then, my lord, obviously there can be some case. But until that is proved, she cannot claim that, yes, A's name has been listed in the NRC. I may also be given, see, he's my brother. I may also given the benefit of that. No. Where is the proof that A is your brother? That cannot be, my lord, accepted. So both 4 and 5th are the, my lord, saying that subsequent development. This is the subsequent development. In fact, second thing, my lord, the NRC is not yet finalized. So it is not a final document. It is not an admissible document as on now. So that cannot be a ground of review at this stage. Now, on the law points, my lord, what my learned senior friends are doing. My lord, they are saying if it is dismissed in demand, my lord, that is the point. That if it is dismissed on demand, it may be they may have the jurisdiction, my lord. The court may have the jurisdiction of review. This is, my lord, probably they are relying this same judgment, my lord. This judgment, 2019, 4 SCC 376. They are relying this judgment. But yes, obviously, my lord, this 2019, 4 SCC 376, my lord. They are in para 29, it is, my lord.
Para,
Para 16 में kindly simple, first of all. Para 16,
just a- yes, please.
para 16, my lord, may I read the para 16 para. Para 16. Abbai Maligai Partnership Firm was a case under the Rent Control Act, and the appeal came from the High Court of Madras. In an eviction petition filed with the respondent number 1 and 2 in the said case, the rent controller had ordered eviction. The rent controller had ordered eviction of the appellants therein on the ground of willful default in payment of rent, as well as on the ground of bona fide requirement of the premises by the respondents 1 and 2, their own business. In appeal, the order of rent controller was set aside as it was founded there was a bona fide dispute with regard to the title of the property, which could be decided by the civil court. The respondents preferred review petition there against, which were dismissed. They approached this court by way of a special leave petition, which were also dismissed. After the dismissal of this special leave petition, the respondent therein filed review petition in the High Court with a delay of 221 days. The High Court condoned the delay and also entertained the review petition on the merits, and not only allowed those review petition, but even reversed the orders made earlier in the civil revision petition by allowing those petitions and ordering eviction of the appellant tenants. In appeal against this order passed in review and revision petitions, the court held that the jurisdiction exercised by the High Court under the circumstance was palpably erroneous. Palpably erroneous. Enter discussion in behalf of the contained in paragraph, which is reproduced below. This is reproduced, my lord. The manner in which the learned single judge of the High Court exercised the review jurisdiction after the special leave petitions against the self-same order had been dismissed by this court after hearing the learned counsel for the parties to say the list was not proper. Interference by the learned single judge at that stage is subversive of judicial discipline. The High Court was aware that the SLPs against the order dated 7/1/1987 had already been dismissed by this court. The High Court therefore had no power or jurisdiction to review the self-same order, which was the subject matter of silence in the SLPs in the court after the silence had failed. By passing the impugned order on 7/4/1994, judicial property has been sacrificed. After the dismissal of the special leave petitions by this court on contest, no review petition could be entertained by the High Court against the same order. The very entertainment of the review petition in the facts and circumstances of the case was an affront to the order of this court. We express our strong disapproval and hope there would be no occasion in the future when we may have to say so. The jurisdiction exercised by the High Court under the circumstances was palpably erroneous. The respondents who approached the High Court after the dismissal of their SLPs by this court abused the process of the court and indulged in vexatious litigation. We strongly depreciate the matter in which the review petitions were filed and heard in the High Court after the dismissal of the SLPs by the court. The appeals deserve to succeed on that short ground. The appeals are consequently allowed, and the impugned order dated so and so passed in the review petition is hereby set aside. The respondent shall pay cost of the stent. Now, Your Lordship may kindly see para 26.2, my lord. In fact, my lord, para 44 may kindly be seen. There, this summary is given, my lord, para 44. To sum up, our conclusion are, where an appeal or revision is provided against an order passed by a court, tribunal, or any other authority before superior forum, and such superior forum modifies, reverses, or affirms the decision put in issues before it, the decision by the subordinate forum merges in the decision by the superior forum, and it is the latter which subsists, remains operative, and is capable of enforcement in the eye of law. That is the first point, my lord. The jurisdiction conferred by Article 136 of the Constitution is divisible into two stages. The first stage is up to the disposal of the prayer for special leave to file an appeal. The second stage commences if and when the leave to appeal is granted and the special leave petition is converted into an appeal. Now, number 3, the doctrine of merger is not a doctrine of universal or unlimited application. It will depend on the nature of jurisdiction exercised by the superior forum and the content or subject matter of sentence laid or capable of being laid shall be determinative of the applicability of merger. The superior jurisdiction should be capable of reversing, modifying, or affirming the order put in issue before it. Under Article 136 of the Constitution, the Supreme Court may reverse, modify, or affirm the judgment, decree, or order appeal against while exercising its appeal jurisdiction and not while exercising the discretionary jurisdiction, disposing of the petition for special leave to appeal. The doctrine of merger can therefore be applied to the former, not to the latter. An order refusing the special leave to appeal may be a non-speaking order or speaking one. In either case, it does not attract the doctrine of merger. An order refusing a special leave to appeal does not stand substantiated in place of order under challenge. All that it means is that the court was not inclined to exercise its discretion so as to allow the appeal being filed. And then 5 point it is point number 5. If the order refusing leave or appeal is a speaking order, that is, gives reason for refusing the grant of leave, then the order has two implications, my lord. This has to be seen, my lord. Firstly, the statement of law contained in the order is declaration of law by Supreme Court within the meaning of Article 141 of the Constitution. Secondly, other than the declaration of law, whatever is stated in order are the findings recorded by the Supreme Court, which should bind the parties thereto, and also the court, tribunal, or other or authority in any proceeding subsequent thereto by way of judicial discipline, the Supreme Court being the apex court of the country. So, my lord, even though it is speaking or non-speaking order, and if it gives reason for refusing to grant leave, my lord, then there are two consequences. Firstly, the statement of law, if it, my lord, contained in the order is a declaration of law under 141 of the Constitution. Secondly, it will be binding on the, my lord, tribunal or the lower courts, whoever it may be.
Okay.
So, my lord, that is the point on my lord, whether it can be, even though as your lordship has seen the order of the Honorable Apex Court as page 82, my lord. Page 82, it is said, my lord, the Honorable Apex Court has dismissed the SLP on the ground, my lord. The Honorable Apex Court has given ground. We, my lord, heard learned counsel for the petition and produced the relevant materials. My lord. We find no merit in the special leave petition. No merit. The same is accordingly dismissed. So there was no merit at all. So the leave petition was dismissed, my lord. Now, my lord, what is the grounds of review? Whether the review can be filed on these grounds, my lord. The CPC, my lord, Order 42, Rule 5, my lord.
Record 657, 2016. WPC 657, 2000. Disposed of 11 to 2016. Paper of February. Yes.
Order 42, my lord.
Which page? No, you are pressing review.
Yes, my lord, review.
Not 47. But
Issue. 47, yes. My lord, before going to that, my lord, can these grounds may be my lord, ground of review? The Kamalesh Verma, your lordship, may kindly see. This is 2013 8 SCC 320. This is
2013,
13 8 SCC 320.
8 SSC 320.
Yes, my lord. This is considered entire things, my lord.
All those points are grounds of
All,
review.
all those points of grounds of review, my lord. In which case the review can be, and in which ground it cannot be, my lord. My lord, your lordship will find all those in para 20.1 and 20.2, my lord. In fact, it has discussed all the judgments of review, earlier judgments of review jurisdiction, my lord. When the review will not maintainable, this is more important, my lord. Para 20.2, I just like point out those points, my lord.
Which para you are
20.2, my lord. 20.2. When the review will not be maintainable. My lord, my submission is that, my lord, this review petition is not maintainable. A repetition of all and overruling argument is not enough to reopen the concluding adjudication, which I have already submitted, my lord. It is the repetition of all and overruled argument. Those arguments were, my lord, argued in the writ petition, both the writ petition, even in my lord tribunal, but those were, my lord, overruled. So it is review not maintainable in that case. Minor mistakes of inconsequential report. They have not said, my lord, any mistakes in the order of this honorable court. Review proceeding cannot be equated with the original hearing of the case. But they are trying to hear the original case, trying to reopen the original case. It is not allowed. Review is not maintainable unless the material error manifest on the face of the order undermine its soundness of results in the miscarriage of justice. Where is the manifest error? They has not pointed out there is any manifest error in the judgment of this honorable court, my lord. A review is by no means an appeal in disgust, whereby an erroneous decision is reheard and corrected by lies only for patent error. So if, my lord, this is said, it is not appeal. if they want the opinion of this honorable court is to be reviewed or altered, they may go for review, appeal. It's open for them. In fact, they have done. They failed there and now coming back with a review, which is not cannot be allowed. Which cannot be allowed, madam. The mere possibility of two views on the subject cannot be a ground of review. This honorable court has taken a view. But view of the petitioner is different. So the petitioner wants that this honorable court's view may be changed, and it may be taken what the writ petitioner is thinking or what the review petitioner is thinking. That is not maintainable. This honorable court has taken a view, given a reason, reason order. Then the 6, the error apparent on the face of the record should not be an error which has to be fished out and searched. In fact, they have not pointed out any error in the judgment. Then the appreciation of evidence on record is fully within the domain of the appellate court. It cannot be permitted to be advanced in the review petition. They want the 61 the evidence to be reappreciated, which is not permissible in review. Then, review is not maintainable when the same relief sought at the time of arguing the main matter had been negated. They sought that tribunal's opinion should be set aside on these grounds, and those were negated by this honorable court. They cannot argue that point again in the review. They are arguing the same point. So all this, the court has clearly laid down this proposition. So my humble submission is, again I'm submitting, this is the abuse of process of law. They are taking time, from 2009 onwards till 2024, going to the tribunal, coming to the High Court, again going back to the tribunal, coming to the High Court, going to the Supreme Court, again coming back to the High Court. What is this, This practice should be stopped. Without going any other aspects, on this ground itself, this review petition has to be dismissed. Secondly, even after 2018, the Honorable Apex Court has passed that order in 2018. Where is the explanation? There is not a single explanation. I'm not saying, filing of any, IF or delay condemnation. Where is the explanation, Not a single explanation why he has come after 4 years to file this review. In fact, even though your lordship was there in the earlier occasion, this, but while hearing the original second petition, just I'm pointing out one judgment of the Honorable Apex Court, This is 2021, 7 SCC 206, the first judgment, of this Honorable Court, the then judge, Honorable judges were no more here in this Honorable Court now, they have retired or either they have gone to some other court. And in the second writ petition, your lordship was there, and his lordship, A.K. Goswami, was there. So he has also retired or gone to this, left this Honorable Court. Now, under such circumstances, whether review can be allowed against the order passed by those honorable judges. This is 2021 7 SCC 206. Here, it's a short order, short judgment. His Lordship D.Y. Chandrasu, Justice, he has delivered his order judgment. The review petition have preferred by the state of Goa, both with delay of 650 days and diary number so-and-so, and diary number so-and-so, both with delay of 651 days. One is 650 days, 600. And Vedanta so-and-so, formerly known as so-and-so, diary number so-and-so, diary number so-and-so, 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 all four with a delay of 907 days. Against the judgment of two judge bench of this Honorable Court in Goa Foundation versus Sisa Stiller Limited. In accordance with Rule 2, Order so-and-so of the Supreme Court Rules 2013, an application for review of judgment has to be filed within 30 days of the date of the judgment or order that is sought to be reviewed. No cogent grounds have been furnished for delay between 20 and 26 months by two parties in filing their applications for review. The judges comprising the two judge bench, Goa Foundation, Mr. Madan B. Lukur and Justice so-and-so, retired from the court on 30/12/2018 and 6/5/2020, respectively. The state of Goa preferred this for review petition in the month of November 2019 after so-and-so is retired, while Vedanta Limited preferred this review petition in the month of August 2020, right after after so-and-so is retired. Such practice must be firmly disapproved to preserve the institutional sanctity of the decision-making of this court. The review petitioners were aware of decision of this court. Keeping in mind of the above, we are inclined to dismiss this review petition on the ground of limitation alone. However, in any event, we also find that no legitimate grounds for review of the judgment of so-and-so have been made out and dismiss this review petition on merit as well. So my submission is, my lord, same. The review petition is to be dismissed firstly on the, my lord, for abusing the process of law. Secondly, on the delay ground itself. Thirdly, delay in late sets. Thirdly, on the grounds of merit. There is no merit in the review petition, so it may be dismissed, my lord. So that is my humble submission.
What do you have to say with regard to the fact that it is not the petitioner, but another person by the name of the petitioner?
My lord, that was
Same
taken
husband.
care of at the time of, my lord, first writ petition itself. Your lordship will find that has to reopen the my lord, writ petition. Then in that case, we have to reopen the writ petition. And that is not a ground, my lord. He has not cited that ground. In the grounds, he has not cited that ground. Grounds of review. There is no grounds, my lord, that his name is, her name is not there in the remarks. He has not given that ground in the grounds of review. And that point is taken care of. My lord, she has not given any evidence at all. She has filed the WS, and then flee away, my lord. And when the NRC is updated, she has suddenly, my lord, wake up and came to the Honorable Court for filing a writ petition. Regarding, my lord, 66 footer 71 better list, whatever documents, those were not under, my lord, not before the tribunal, because they have not pleaded anything in the tribunal. They have not given any evidence. My lord, your lordship will find page 71, my lord. That is the point. In page 71, the earlier this Honorable Court has taken care of that. Learned counsel for the petitioner submits that petition was not declared as a de-voter at any point of time. This point was taken. Even till today, she has not been declared as de-voter. Therefore, declaration by the tribunal that the petitioner is a foreigner is untenable. On the other hand, he submits that there is another de-voter by the same name at that of the petitioner. Perhaps because of such confusion, tribunal had arrived at the aforesaid conclusion, which is clearly erroneous on fact. On a query by this Honorable Court, as why petitioner has approached this court after more than 6 years, learned counsel for the petitioner submitted that firstly, she is an illiterate lady, unable to comprehend the serious consequence of her defeat. And secondly, she had no knowledge about the impugned order dated order till 30/12/2020. Only when police started searching for her, she had come to know about the impugned order. Therefore, court may intervene in the matter and grant some relief to the petitioner. Mr. Bhagavati, learned counsel advocate, government advocate, however, opposed the submissions made to the learned counsel for the petitioner. He submits that full opportunity was granted to the petitioner by the tribunal, but there was deliberate default on the part of the petitioner. Petitioner cannot take advantage of her own default. He also submits that reliance placed by the petitioner on the voter list to show that the petitioner has not been declared as the voter is misplaced and untenable, in as much as the documents relied upon is of 2014, whereas tribunal passed the order on 14/07/2009. There is no explanation at all for the inordinate delay in approaching the court. In such circumstances, he may submit no case for interference of this met out. We have heard the argument of the counsel parties. Proceeding before the foreigner tribunal is summary in nature. It is not in full fledged civil proceeding like a civil suit. The Honorable Court, in the case of Sarbananda Sonowal versus Union of India, has held that the procedure adopted under the Foreigners Act 1946 and the Foreigners Order 1964 is just and fair and reasonable and does not offer any constitutional provision. All that the court is required to see at this stage whether a fair opportunity was provided to the noticee. In this case, the petitioner, when the petitioner had received the notice of the tribunal and had engaged counsel to defend herself, subsequent repeated default that without any sufficient cause cannot be accepted. Moreover, the impugned order was passed on way back in 4/7/2009. Writ petition has been more than 6 years thereafter. Explanation given by the petitioner that she is an illiterate lady who is prevented her from approaching the court earlier would be no assistance to her in as much as she had engaged the counsel to defend herself in the proceeding before the tribunal. Therefore, second explanation given that she has come to know about the order of tribunal only in 2015 also cannot be acceptable because she was aware of the proceeding before the tribunal. Insofar as merit of the case is concerned, we are not inclined to enter into the aspect of the matter, since on due consideration of the material placed before the tribunal had arrived at a conclusion which is certainly a possible conclusion based on the materials on record. So this is the findings of the learned
No, please
court
proceed,
members.
but there is something.
Yes. The issue relating to recall of ex parte order has already been gone into by the full bench in full bench of this honorable court in the state of Assam versus so Muslim Mandal 2013 1 GLT full bench 809. Only on special or exceptional circumstances, ex parte orders can be recalled and not in routine manner. Therefore, the central government has issued notification providing to filling of application seeking recall of ex parte order within a specific period. However, petitioner has not availed any such remedy. Therefore, we are of the view that there is no merit in the writ petition to warrant any interference with the order of the tribunal. So whatever.
No, then there is another observation.
Yes.
After that citation of the full bench.
Yes. Therefore, we are of the view that there is no merit in the writ petition to warrant.
Before that, after the citation.
Yes. Only on special exceptional circumstances, ex parte orders can be recalled. This is the point, my lord. Recall and not in routine manner. So it is not a routine manner. It can be recalled, my lord. The statute has provided the my lord, filing of review petition against the ex parte order, the Foreigners Tribunal's Order 1964. This is, my lord, after amendment that was brought, and that is given to them. But that is also, it is said, only on special or exceptional circumstances, ex parte orders can be recalled and not in routine manner. Therefore, the central government has issued notification.
Thereafter, where is that?
Thereafter, yes.
Where is that
Thereafter,
notification?
yes. This is, my lord, the amendment of the 1964 rules. My lord, the 2013, after 2013, the review jurisdiction was not there. My lord, 64 rules, my lord.
3A.
Yes. That was not there. 3A was not there. That was notified only on, my lord, 10th of December 2015. After the judgment of the, my lord, the full bench. Full bench says, my lord, only on special and exceptional circumstances, ex parte orders can be recalled and not in routine manner. And accordingly, thereafter, my lord, the central government has issued notification providing that provision has been brought into the order of 1964 rules. But she has not availed it much of the medic. Who has prohibited her? After filing written statement, she was sleeping. And only when the, my lord, NRC was updated, when her name was not found in the list, she has wake up. Now she wants this court to, my lord, exercise all the, my lord, power, whatever, my lord. And it is also said, my lord, D voter, she submitted 2014 voter list. She was declared foreigner in 2009. So her name should have been deleted from the voter list if her name is there. 2014, no question of D voter again, my lord.
Yes, Mr. Kohli, what is the status of the petitioner now? Don't tell us that you have to obtain instruction. Whether the name of the petitioner figured in the voter list or it has been deleted from the voter.
My lord, regarding this matter, I have taken instruction.
What have you been doing for all this time? You know that this case will be listed today.
Court has been given, my lord.
No further sorted. See, the order of the tribunal was of 2009. Right? Come to page number 65, annex of 12. There's a voter list of 2015. And the petitioner's name still figured in the voter list. Down below, left side, showing her Mr. Mahmood, where is your voter ID card?
It is not with me.
Have you annexed
At
anywhere
present.
in any of the writ petition?
Voter list I have annexed.
Voter ID card?
No, that is not annexed. I remember one circular of the government, my lord,
Hmm.
that the tribunal has no power
Hmm.
to direct the executive authority to delete the name of the person concerned,
Some of the cases earlier done, but thereafter the High Court have clarified. Will not be matter.
to
It
delete
is now
the,
only their
it
earlier
is
they
the
used to
job
do
of the executive,
only
not the
opinion.
tribunal.
Now they are giving only the opinion. Nothing else.
Yes. They can simply give an opinion. And the High Court under jurisdiction also is, I think, is bound by that because High Court is only working as supervisory jurisdiction.
Hmm.
So either the order of tribunal should be allowed or rejected,
You're right.
either of the two. So that is one thing. But I will give some clarification regarding the submission of my learned friend.
Definitely. We'll get back to you. Just a minute.
And
Just a second. এইটা শেষে না para পারিবে এটা এখানে এই জন্য আর 2 নম্বর সাথে wicket like a Roman for Roman for like Yeah.
With regard to the delay which you have raised a question, now that there cannot be a delay with regard to any such fundamental rights. There are judgments of the apex. The Honorable Apex could also consider these aspects in various other judgments and the recent judgments, old judgments. When there is an inordinate delay, whether the violation of fundamental right,
Yes.
you are saying that you had a right, so even if there is a delay, so that need not be considered and the should be allowed. Now, when there is an inordinate delay has been considered by the High Court in your first writ petition and also in your second writ petition, which has been also upheld, the decision of the High Court has been upheld by the Supreme Court.
Yes.
What right you will have?
Yes, I have a right, my lord.
Tell us.
Uh, First Lordship, what my learned friend has submitted,
Hmm.
I have each and every answer.
Hmm.
My learned friend has said that I have not argued on review petition. That is not correct. Because at the very starting point of my argument, I started, kindly see page 9, my lord.
See, entire case of you is that there was another lady by your same name, husband name is same,
Yes,
but the father-in-law's name is different,
yes.
and that aspect has not been considered by the
Considered.
tribunal. Or this.
So it is a serious matter.
What we found is that the issue that was raised before the tribunal, you accepting filing of your written statement that also after 3 days, you did not adduce evidence. It is not the tribunal did not give you ample of chance to place your evidence, but of your own,
Yes,
you did not choose to place your evidence.
that is correct.
While you're filing written statement, you have not filed any such
For that, my lord,
certified copy of the voter list or whatever. So the ground taken by the tribunal in rejecting your case, holding that you failed to discharge your right to prove your nationality as required under Section 9 of the Foreigners Act, was upheld by the coordinated bench of this court earlier in 2016. And you approached this court after 6.5 years, saying that the police, only when the police came to look for you, came to know on that. That was dismissed. You did not prefer any review, did not prefer any SLP. Then you filed an Order 9 Rule 13 application. That was rejected by the tribunal. Then you preferred again a writ petition with the same conditions, same grounds, saying that there is another person by your name, husband's name is same. Again, the High Court considered that aspect and rejected your second writ petition, against which you went to, in an appeal, you went to Apex Court, and the Apex Court also dismissed your appeal, upholding the decision of the second decision of your time. Now, what Mr. Payang has pointed out, even if the order of the second division bench judgment is considered in the review, then the order passed by the first division bench of the High Court will be enforced, which you have not challenged, which you have not taken a ground in this review petition. He has also stated that since your appeal was dismissed on merit, where is the question of filing such review petition? In that case, he has cited those. Now, tell us by which particular provision of law this review petition will be entitled.
my lord, first thing, Lordship, kindly see 1964 Foreigners Tribunal Order.
Yes.
Order 4. Kindly have a look to Order 4
Kindly read.
and see. Issuing commission for examination of any witness and 64 order, let me say.
Yes, yes, please.
64 order. It's
Which provision you like to show?
provision, my lord, that is the, there is a provision of issuing warrant of arrest.
Hmm.
1960 order to Vice President. Now, here a person did not come to court, 64 order to Vice President. Now, there is a provision of issuing warrant of arrest. And that has been reiterated in the year 2013 also. 2013 also, that may be seen at page 138 of my book, my lord. Of my book that is also there. Issuing warrant of arrest against the proceeding if he or she fails to appear before it. Now, it has been reiterated in the year 2013. And it was also in force in 1964. That if the proceeding does not come, then tribunal has the power to issue warrant of arrest to cause his appearance a must. Now, in almost every cases, my lord, we see that whenever persons once or two times do not come, then the tribunal easily declare them as foreigner. But law says that you issue warrant of arrest. Because these types of people are illiterate and also many aspects they are irresponsible. So she was somehow asked that as there is no letter D against your name, so you are not the proceeding in this case. Rather, another joyfulness of your same village, whose husband's name is Shamsul Haq, but grandfather's name is Muhammad Ali. Against her name there is D, so she did not come. So had the learned tribunal issued warrant of arrest, then she would have come, would have filed her proper documents or could have adduced evidences. But she understood this point when police went to her house and she came to the Honorable High Court, but High Court has dismissed the matter. But as the power is also vested upon the tribunal to set as an ex parte order, so she filed petition that
Mr.
was...
Pramod, Order 4 of 1964 orders
Yes,
is the power of the Foreigners Tribunal,
yes.
is the power.
Power.
And while deciding any suit or a matter before the tribunal,
Yes.
it has the power to exercise
Warrant of arrest. Yes,
the civil court and a magistrate. But what is the procedure to be followed while disposing any such or deciding any matter before the tribunal?
4, that is
It has been decided-
order 4, my lord. Powers?
Listen to us first.
Yes.
Order 4 relates to the power of the tribunal.
Yes.
But order 3 provides is the process, how the matter has to be decided, the disposal in question.
Yes.
Now please come to order 3, suborder 8.
Yes.
That is how the procedure is.
Yes. 10 days. 10 days time, this further 10 days in this year, dates are fixed, man.
Fixed.
But thing is
But
this,
thing
man.
is this, it is up to the particular tribunal. Now procedure has been followed. You have been given ample of chance. It is not that you did not get any chance.
To that extent, my I am satisfying your lordships.
Hmm.
Court is also the persons of this world. Now, if a person files an application for certificate copy, 3 months, 4 months, 6 months are taken. There are so many instances. Even in many cases, certificate copies are not furnished. All my learned friends below, they have this bitter experience. Everybody does not tell a lie. So 10 days, this is totally impracticable procedure. Because certified copies, unless we get, how we can prove our case? So certified copies are not produced, not given in time. 10 days, forget about it, years together, not given. In Jorhat, my lord, they do not give the certified copy. 1 or 2 tribunals are there. I have got so many, for which I have filed cases also for these certified copies. That is why in Muslim Wonders case, it is clearly said that whenever party will file application seeking certified copies, it is the duty of the.
When did you brought it to the notice of the tribunal that you have applied for the certified copy and it has not been provided to you? On which date you filed such applications
My
before the
lord,
tribunal?
let
Kindly
me-
show us. Show us.
That is not, that is. that
Don't
would
make
be
any
not be
statement
necessary.
before the court unless you have
That will
applied
satisfy
for.
your lordship.
Before
because-
satisfaction, Mr. There is a limit of everything. You go on making submission, it is not. We are
No, no,
sitting in
no.
review. We are not sitting in an appeal. So please tell us on which date you have applied for the certified copy and made submission before the tribunal that although we have applied for the certified copy, it has not been provided to us. On which date? Is there any made submission before the? have
Here
you
is not,
received
but
in that
here
case?
is more than that, my lord, I am showing.
We are
Because,
in-
my
just
lord, when
mind it,
inquiry
we
is
are in-
made, the
Mr.
person
Mahmood,
is,
we are not hearing any appeal. We are in review. So make your submissions within that periphery only,
yes,
not beyond that.
yes. 2013 8 SCC
Yes,
320 para 20
2013.
plus 2013 8 SCC 320 para 20 within bracket Roman 4. Here, here lordship would say, it
Same
is
judgment.
review,
Same judgment.
yes.
Right.
What my learned friend
Comrade
says,
Verma
yes.
only you are talking about.
Judgment should be the same because we do not create any judgment. Review is not maintainable unless the material error manifests on the face of the order, undermining its soundness or results in miscarriage of justice. Now, here is another joyful lesson, serious miscarriage of justice. I am repeatedly saying, everywhere I am saying that I am not that joyful lesson. That's why I remained absent. Now,
Whether that issue was taken in the first writ petition, second writ petition or not.
yes, that was taken.
Now, in the
The-
even in the second writ
The
petition,
High Court also said that it is duly considered. That is not enough. Duly considered means was
then you went to appeal
with soundness.
for the Supreme Court, then what will happen?
Well, there should be some basis. There should be some basis. Now, lordship, for a moment, I invite your lordship, kindly have a look to your lordship. Just you have my learned friend lordship has said that our SLP was dismissed on merit. Merit what is there? Page 82. Kindly see page 82.
We have seen that last line.
Last line. We find no merit in the special leave petition. The same is accordingly dismissed. There is hired learned counsel for the petitioner and peruse the relevant material. We find no merit in the special leave petition. So, the merit what is there, but in 4 lines there is no discussion. That is why further distillery said, my lord, I am reading, my learned friend has not read perhaps that portion of the order. Here, para 28.
Which judgment?
This further distillery, that is 2019,
Footage one.
2019 4 SCC 376, para 28 and 29. So Honorable Supreme Court has said we find no merit. But is it a speaking order? That is why this judgment is there. Here, 28 can you see? In the instant case, since special leave petition are dismissed in limine without giving any reasons, lordship would say, the review petition filed by the appellant in High Court would be maintainable.
Which para?
Para 28. In the instant case, since the special leave petition was dismissed in limine without giving any reason, no reason is given, my lord. Only that we find no merit. But what are the reasons? Not there. So it is also the Supreme Court's order. And Lordship is aware, here miscarriage of justice is there. That is a good ground of review. Because two persons of the same village are in the same name, against one name, D voter, but police is not behind me. But I have no deal letter, police is behind me. So can it be not verified? It should not, in my humble opinion, it should be verified. Even by this Honorable High Court also, the SP Gwalpara may be directed, you inquire the matter whether this Joyful Nasa has the letter D. That High Court in jurisdiction can has some power. It can direct the SP that you verify who is the real Joyful Nasa against whose name there is D. So here the Honorable Apex Court says that in the instant case, since special leave petition was dismissed in limine without giving any reason, the review petition filed by the appellant in the High Court would be maintainable and should have been decided on merits.
Yes.
Order dated so and so passed by the High Court is accordingly set aside and matter is remanded. Now, Lordship, High Court has said that we have considered that aspect that there is no letter D. How the High Court has considered? Because High Court had not inquired the matter. I say there is no letter D. My learned friend says there is letter D. Then it should be decided, examined, or inquired into by some authority. Nothing, no authority is there.
Not inquired. Then
So, the Honorable Supreme Court, in this case, we find the special leave petition was dismissed with the following order. Following order passed on 5/1/2012. Here we find no ground to interfere with the impugned order. Writ appeal number so and so, decided on so and so. Special petition is dismissed. Here also, the special leave petition was dismissed on so and so in limine and without any speaking order. What is the speaking order? Let us not confine only to a direction that this is our goal. That is not. There is no speaking order. In my case, Honorable Supreme Court said we dismiss the SLP on merit. But no speaking order is there. The speaking order means what? There should be reasons. And then if the order is dismissed, then it is merit. So merit does not mean that it has been decided on some well-founded decisions of the Honorable Court, both factual as well as legal. So that is one aspect of the case. Another aspect of the case is this. High Court says that it is considered. How considered? How considered? I have considered that there are two joyful nasas. What is this? The joyful nasas High Court should have been inquired into, because this is a question of my Lordship is correct that again I am coming to High Court because I have no way.
okay. Okay.
Necessity knows no loss. So here is my question of life and death. I can be served only by High Court or by Supreme Court. So repeatedly I am coming because my grievances are not reduced to it. Now, Lordship, another thing was that regarding my learned friend has cited certain citations. My Lord, binding authority is what? What is the extent of binding authority? Courts should not play reliance on some decisions of the Supreme Court without tallying it with the factual points which were available in a given case. So what my learned friend has cited, those were in a peculiar situation considering peculiar facts and circumstances of the case. But here is a case, two joyful nasas. One is D, another is without having D. So those are not at all applicable in this case. Because the facts and circumstances do not tally with those cited cases. So binding authority does not mean that you will, Sarvananda Sonowal 1 always is brought. That is absolutely a wrong conception. Sarvananda Sonowal's one's issue was that whether IMDT is constitutional or legal or ultra virus of the constitution. That was the only issue, my lord.
Did you file any review petition against the Sarvananda Sonowal Judgment 1?
No,
Before
it
the
is the
apex
issue.
court.
In the judgment, it is written. The issue. I am reading that judgment, Lordship, just now find that here in the first 3 or 4 paras, issue, it is Honorable Supreme Court said that issue in this writ petition is this, whether illegal migrant determination by tribunal act is legal, constitutional or ultra virus of the constitution. So that was the issue. Discussing, they have discussed many things, Honorable Supreme Court has discussed many things, but issue was that whether that is ultra virus of the constitution. At last, Honorable Supreme Court held that yes, the IMDT is ultra virus of the constitution. So all the cases which are pending before the tribunals, IMDT tribunal shall now henceforth be transmitted to the Foreigners Tribunal constituted under 64 order. So, my lord, that was the real thing. But in Sonowal 2 case, my lord, very nicely everything is discussed. Fair procedure, every opportunity should be given
So
to a
if
person.
something has been observed by the Honorable Apex Court in Sarvananda Sonowal 1.
Yeah.
Which is may not be liked by you.
Yes,
bad,
there is a flood
and
of
something that
foreigners.
is, again, similarly in the Sarvananda Sonowal 2,
Two is
there are some other discussions which you are now harping upon. How can you say one is bad, one is good?
no. One was regarding one particular issue.
The second one is also a particular issue.
No,
of
second
issuing of
was
the
not for
notification of
particular issue.
2005.
Second was
The second
regarding
was how the government wanted to cover up which they have not done as per the direction of the Sarvananda Sonowal. That was the challenge in the Sarvananda Sonowal 2. That's
in
what we
Sonowal
observed.
2, my lord, 2006 order was challenged.
That is why the Sarvananda government
2006 order was
Government-
challenged.
government covered up what was the direction given to them. Now they have brought out a separate notification in 2006. Now
Yes.
how they have covered up, you have seen, and that was also a decision taken by the Apex Court, that not in terms of the order passed by the Apex Court in the Sarvananda Sonowal 1, and also not maintainable under law. That is why 2006 notification was set aside.
6 was yes, that
Why?
is correct.
Why?
No,
So there was some discussion in that regard. So in one case, according to you, those discussion in Sarvananda Sonowal is bad because issue is this. And in the other one, Sarvananda Sonowal discussion is good.
yes, I
There is issue also,
am
there
on
is a
that.
very
I am on that.
particular-
There is reason, my lord. Because in Sonowal 1 case, issue was only one.
And what
Whether
about the Sarvananda
IMDT
Sonowal
is
2?
unconstitutional or alternative. But in
See,
Sonowal 2,
If
my
you
lord,
agree with any such decision or
for
observation
a
made by
moment,
the
my lord,
Apex Court,
2006
you cannot make
order,
a submission
we are
before
having
the High Court.
2006 order.
Mr. Mahmood, don't go beyond your limit. We are not here to discuss any such observation made by the Honorable Apex Court. If
No,
you
no,
have
no,
to,
no.
you
I
agree,
am also
we are
bound by
not on
law.
that.
But
And we will not
2006
hear any such submissions. We will not hear any such submissions. We will not allow you to make any such submissions.
But my
regarding
learned
any
has cited, that is why I
That is
am
observed.
replying.
You cannot say that observation is good or bad. At
No,
this
no, good
stage,
or
not
bad or
before the
not.
High Court.
Good
Not
or
before
bad,
the-
I am not telling. Issue was one.
Mr. Mahmood, keep your limit. Otherwise, we'll stop you for argument further.
No, no, no. That I am within
Keep
my
your
limit.
Don't go beyond that.
Now,
No,
binding authority, kindly see, I am
make your
citing,
legal submissions. Don't give
I am
out your-
citing my rulings. Yeah.
Make your legal submissions, not go beyond that.
My lord, these are legal. This is Supreme
No,
Court.
that's right. Whatever you submit, we'll hear.
Yes.
Don't discuss. Yes.
But in a review petition, the other side cannot argue such a long point. That is also
It
prohibited.
has been pointed out. You point out whatever is
Yes.
there in it.
Now, Lordship 2006, 1 SCC, 368,
Good.
para 9 and 11.
Mm.
It is said, law declared by Supreme Court, interpretation of judgments.
Mm.
Held
2006.
courts should not place reliance
Yes, yes.
on decisions without discussing as to how the factual situation fits in with the fact situation of the decision on which reliance is placed, just which I have argued a few minutes
2006.
earlier. So Lordship would kindly say,
Kindly give us the citation, 2006,
2006, 1 SCC, 368,
para,
para 9 and 11. So these are the things I am discussing since earlier. So this is now law I am showing. Earlier I was telling,
anything else?
then Lordship would say here, it is my lord 2000, 2000, 2000, volume 1, SCC 666, para 14 and 17. Here, High Court is a court of record, power of review inherent in High Court, Civil Procedure Code, section 114 and order 47.
M.M. Thomas case you are treating about, probably.
Yes, M.M. Thomas case, yes.
Hmm.
Now this is 2005, 4 SCC 741, para 888990. Here, my lord, very important thing is discussed, subsequent development. If there is any subsequent development, that is a good ground of review.
BCCI.
Yes, PCCI. It is also in order in section 114. Kindly have a look to 114. It is in the section itself is written, the subsequent development, if anything, may be also considered in review petition. Lordship, now what is my subsequent development? That my son's name is recorded in NRC. My brother's names are recorded in NRC.
Did you prove it before the tribunal?
Hello?
Did you prove it before the tribunal?
No, because it is prepared afterward.
No,
Afterwards.
did you prove it before the tribunal?
No,
that
no,
those were
that-
siblings?
No, well, that it is the case of 2009 and NRC draft list finally
That's why I'm
published in
asking you, have you
2018.
proved before the tribunal that those were your siblings whose name now been in the draft list of the NRC?
No, I said that actually I did not appear because D was not there. So learned tribunal should have issued warrant. That was not done. So very easily I was declared as foreigner.
Okay.
But actually some hard steps should be taken considering because of this person's illiteracy and their irresponsibleness. In every case, Lordship is getting, Lordship has also understood the conduct of these persons. We are also many times dissatisfied with this. I told them so many things, but they are habituated
Yes,
with such
next,
type of
next,
things.
next.
Then Lordship would say, that is very important thing, that subsequent development is a good ground for review. Then 2001, 2 SCC 721, para 23. Here, literal or strict construction held ought to be scrupulously avoided if inevitably creates various anomalies and finally defeats the ends of justice. So, Lordship, in these matters, what are the extent of burden of proof? Very injustice has been done in many cases with such persons in the name of burden of proof. Burden of proof does not relieve them also to prove their honors. Now, almost all these cases, very literal interpretation are made and ultimately it causes injustice. Public documents are always doubted. And the enumerators, my lord, enumerators go, their qualifications are matricular or higher secondary, even 5 times, 10 times, if they are told the names of a Muslim person, they cannot write properly. But for the mistakes in their names, they are made foreigners. These are the truth of the society. Then my another submission, Lordship, 2012, 1 SCC 425, para 13, my lord.
2012, 1 SCC 435.
425, para 13. And then presumption of public document or certified copies. So, when some documents were furnished, it is said that they have submitted photocopies. But my lordship is aware, if photocopies are submitted, then why the learned tribunal recorded this? Learned tribunal should not have recorded this. It normally happens, photocopies are submitted, original are shown. This is the procedure. And this is done. Now in tribunal's order, we see, tribunal says that the photocopies of those and those documents have been submitted. If absolutely photocopy, no original was shown, then tribunal cannot write down this because that is beyond record, beyond the law. So that is a good ground that presumption should be in favor of the person who submitted it, and any objection regarding any document should be made at the first instance. Should be made at the first instance because at the time man would get some chance to explain the position. That is also there. That is any objection to any document, my lord, that lordship may. I have given so many citations in this regard on earlier occasions. Here today I am also giving another judgment, my lord, here. It is 2006 1 SCC 479, para 36, 37, and 64. Court always need not wait.
Kindly give the paragraphs again.
36, 37, and 64.
36, 37, and 64.
Sorry, yes. The Honorable Supreme Court has said, court always need not wait for a statute to provide relief. Constitution of India, Article 142 and 136, inherent parts of the power of the court, power to mold relief is held discretionary jurisdiction of a court and not always be confined with a statute. So, though there is no status, even then, my lord, the court should provide them relief without taking any rigid view. Then one thing that I was telling, objection should be official records without objection intended in evidence, not disputed, their contents are proved. So here, my lord, if the photostat copies were furnished and if those are not compared or shown with the original record, they should have raised objection at that moment. Then I would have got a chance to provide my explanation. But at that time, they are totally silent. But in High Court, they are raising these issues. So that is not permissible. So, my lord, in the interest, so when the Honorable Court is saying that on merit, here on merit, it should be taken that in limine. It should be substituted by the word at in limine. The Honorable Supreme Court said when the order is passed in limine without any speaking order, so that is also reviewable. So here the on merit word should be interpreted in Levine, because nothing is discussed, no speaking order is there, and that is clarified in the Khode distilleries case. That it should be a speaking order, then only it will be merit. So all these things clearly indicate that this person, another matter has my learned friend said that regarding delay, I have given long reasons of delay. That is page 9, Roman 2. Very long explanation I have given, but my learned friend says there is no ground shown regarding delay. I am reading now then again.
No,
Perhaps,
we'll read. You have to read.
yes.
Okay.
Then
You see
page
page number
9,
9, Roman 2, we have.
not only Roman 2. There is also Roman 2, Roman 3, Roman 4.
All the grounds.
All are the grounds on delay, and as well as another one, 4 is ground regarding the recording the names of the siblings or near close relatives name in the annals. That is Abdul Quddus. Page that is para 23 and 24. So these are ground. In addition to another ground that Joyful Nisa is having no D in her name's front.
Okay.
So these are sufficient good grounds of review.
Okay.
So review should be allowed. Matter may be remanded back.
Well, to Anand.
Matter may kindly be remanded, because I know that I am tired, because so many times I have come to High Court, to Supreme Court, because I have no alternative. So my tiredness should be felt by this honorable court, because High Court has a decision that High Court should act like philosopher, guide and friend. This is the decision of our High Court. So that decision should be followed, because the decision of a coordinated bench is binding upon another coordinated bench, unless it is annulled by the full bench or larger bench. That is the subject.
Mr. Emil Mahmood, learned counsel appearing for the review petition, class rate petition. And Mr. H. Kuli, Standing Council Election Commission of India, 40 respondent. Also heard Mr. J. Pang, Standing Council Home Department Assam, 40 respondent number 3, 6 and 7. As well as Mr. P. Sharma, Digital Senior Government of Assam, 40 respondent. During the course of the argument, Mr. Mahmood relied on the provisions of Order 4 of Fairness Tribunals Order 1964, The decision and the following decisions of the Honorable Supreme Court. 1, 2, 3, 4. 2019 6 SCC 604. Para 23. 2013 8 SCC 320. Para 20 within bracket Roman 14 Roman 14 Roman 4. 2019 4 SCC 376. Para 28. 2006 1 SCC 3680. Paras 9 and 11. 2000 1 SCC 666. Paras 14 and 17. 2005 4 SCC 741. Paras 88 89 90. 2001 2 SCC 721. Para 23. 2012 1 SCC 425. Para 13. 2006 1 SCC 479. Para 36 37 and 64. In support of his argument, Mr. J. Pang, standing counsel from the court, relied on the decisions of the Honorable Supreme Court in the case of in the decision, the following decision. 2019 4 SCC 376. 2000 6 SCC 359. The about 2019 4 SCC 376. Para 60 and 26.2. 2006 SCC 359. There are 44. 2013 8 SCC 320. 20.2. Para 20. And 2021 7 SCC 20.
My lord, with due apology, my lord, my son has come a very good decision regarding merit. It is 2006 SCC 359 para 45. Here, what is the meaning of merit has been discussed by the Honorable Supreme Court, that only said it is dismissed on merit. But what is merit?
2006 SCC 359.
359 para 45. Very lucid discussions have been made.
Delay makes is another judgment, recent judgment of basically civil appeal number, my lord, 5027.
Civil appeal number
5027.
5027.
Yes, my lord, of 2024.
Decided on
My lord. This is, date is not found, my lord. It's
down
been-
below. Last page.
Last page, yes. Yes, on 18 April 2024.
18th April 2024.
Yes, my lord. This is latest judgment, para 12, my lord,
Para 12.
para 12.
What is
Then-
the party's name?
Party's name, my lord, Mrinmoy Meiti. Mrinmoy Meiti versus Sandra Kole and others. This is full bench decision, three bench decision. Para
That's
12,
regarding the delay.
delay in nexus, my lord.
That's true.
Para 12, 13, And 14, yeah.
In that case, the earlier decisions of the apex court are
Yes,
also.
has been discussed, madam, already discussed.
I have also given delay matters in my petition itself. My lord,
That
item
will consider.
five may can be taken another day.
We are here because to dispose of these 5 matters. That is why the
Because
bench has been constituted.
Sometimes confusion arises, same type of cases.
Hmm.
There are other 4 matters, so 5 may be taken another day.
Thursday. Thursday.
Yes.
Take it. Okay, we'll come back at 2 instead of starting a fresh matter.
Yes, the 5 on Thursday,
5 on Thursday.
obliged.
Will appear for the item number 2? Mr. Bormia will appear? Okay, we'll come back at 2 and we'll hear you.
Down,
Just. Please take it. Yes, please, Mr. Pro.
Lordship, grounds, page 12, Lordship. These are the grounds I have taken in the review, Lordship.
Just a minute.
A, B, C, D.
Yes, please.
Lordship, page 12 are the grounds, Lordship, page 12 and 13. May I read, Lordship?
Please.
For that, in the instant case, there is no enquiry at all made by the enquiry wizard, and so-called enquiry report prepared by the enquiry wizard is made behind the back of the petitioner. And as such, in the enquiry report, the petitioner's father's name recorded as late Ikram Ali instead of Sonuddin Dewani, Sonauddin Sheikh, and in the subsequent case, the same enquiry officer recorded the father's name of the petitioner as late Monser Ali instead of Sonauddin Dewani. But due to subsequent case and on the prayer of the petitioner, the tribunal directed the police to cause an enquiry about the father's name of the petitioner. And accordingly, the police made an enquiry and found that the petitioner is the daughter of late Sonuddin Dewani, alias Sonuddin Sheikh, but the learned tribunal as well as this honorable court disbelieved the petitioner's pleadings as well as evidence, which is an error apparent on the face of record, and hence the impugned order is bad in law and liable to be set aside in court. For that, in the instant case, the petitioner submitted a written statement mentioning of her family tree in details, and in support of her statement, she adduced evidence of herself as DW1, evidence of her uncle Monuruddin as DW2. To prove the school certificate, she testifies DW3, who is the UD of the SBP Memorial HS School, and her son as DW4. Although petitioner in her pleadings and evidence that DW2 Monuruddin is her paternal uncle and having her school certificate wherein her father's name appeared, and that the name of DW2 appeared in the Exhibit A along with her parents. But while deciding the matter, this court held that there is no pleading at all that DW2 Monuruddin is the paternal uncle and the petitioner was the students of SBP Memorial HS School, which is an error apart on the face of record, and hence the impugned order is bad in law and is liable to be set aside and quashed. For that, while the second case was referred to the same tribunal by the purported enquiry with the allegation that the petitioner is a suspected foreigner who is the daughter of late Monser Ali, the petitioner raised objection and prayed for police enquiry for actual identity of her, and on enquiry, the police clarified that she is the daughter of late Sonuddin Dewani, Sonuddin Sheikh, and hence from the discovery of new and important matter and for other sufficient reason, the impugned order is required to be modified and give relief to the petitioner. For that, the petitioner specifically stated in details of her family tree, both in the pleadings and in evidence of her case, and the same having been reflected in the NRC final list, which are prepared by quasi-judicial authority after following due procedure, wherein her close family members have been declared as Indian citizen, and therefore the opinion rendered by the Foreigners Tribunal as well as opinion of this court is required to be reviewed. In view of decisions dated, so passed by the Honorable Supreme Court, reported so Abdul Quddus versus Union of India, and give relief to the petitioner. For that, any view of the matter, the impugned order is bad in law, liability is settled. Lordship, then come to page 71 of this Honorable Court's judgment and order, Lordship, page 71.
Yes.
Lordship, page come to 74, relevant paragraph. I will read, Lordship. Paragraph 5, page 74.
Yes.
We have considered the submission of the learned counsel, also perused the records of FT case number so-and-so requisition. On perusal of the written statement, it is seen that there is no whisper that the projected father of the petitioner has one brother by the name of Monuruddin, nor there is any pleading to that effect that the petitioner was the student of SBB Memorial HS School, Morni, and she was issued certificate by the said school. The DW3 is one Osim Jyoti Das serving the SBP Memorial HS School, Moronoi, as the UDA since 2/7/1999. As per his deposition, the said certificate was issued by one Kamal Goswami, the principal, on 1/4/2017. He simply stated, as per the school certificate, the date of birth of the petitioner is 23/3/1970. However, he deposed that he cannot say if the petitioner and the student as against whom the certificate is issued are saying or not. The said deposition of DW2 itself demolished the force of the certificate, inasmuch as the person proving the said certificate himself has deposed that he is not aware of if the present petitioner is the student of one named in the certificate. Thereafter remains the evidence of DW2, Monaruddin, whom the petitioner has projected to be the paternal uncle. It is the contention of Mr. Soikia that as the evidence of the said DW2 remains unchallenged, as such the same itself has full evidentiary value. On the basis of the said evidence, the link of the petitioner is well established with her projected parents, whose names are recorded in the voter list right from 1966 onwards. In support of his contention, Mr. Soikia relies Abdul Khalik versus Union of India and others reported so and so. We have gone through the said decision as relied by Mr. Soikia. This is a case wherein on receipt of the notice from the tribunal, the appellant filed his written statement contending his claim of his lineage in order to establish the fact that he is an Indian national by birth. In the said written statement, the appellant pleaded the name of his grandfather, whose name appeared in the voter list pertaining to the year 1965. The said appellant, in support of his contention, examined witnesses, including himself as witness number 1, the Gaubura of the concerned village as witness number 2, and one of the villagers as witness number 3. The said witnesses were not cross-examined by the state. The tribunal, after appreciation of the evidence, opined that appellant was foreigner coming to India after 25/3/1971. After rejecting the evidence of witness number 1 and 2 on the ground that the Gaugura, the witness number 2, in his evidence stated that he does not know the name of the appellant's grandfather, and he also does not know who is Abdul Wahab. The appellant filed writ of petition challenging the opinion, which was also dismissed by the learned single judge, upholding the opinion rendered by the tribunal. Thereafter, the writ appeal was filed, wherein the said appeal was allowed by holding that witness numbers 1 and 3 categorically stated that Abdul Wahab is the grandfather of the appellant, and under such circumstances, evidence of the Gaugura, witness number 2, would not demolish the case of the appellant as revealed from the evidence adduced by him. More so, when there was no cross-examination of any of the witnesses examined. The said case so relied by Mr. Soikia can be distinguished inasmuch as the present case is in hand. There is no pleadings at all. The DW2 Monaruddin is the paternal uncle, and the petitioner was student of SBP Memorial HS School, Mornoi, and school authority issued a certificate in her name. There is no whisper to that effect, even by the petitioner in her evidence. It is the DW4, son of the petitioner, who is aged about 31 years, introduced the said school certificate, which was issued on 1/4/2017 and exhibited as Exhibit 1. Further, the DW2 Monaruddin, while in his deposition, did not rely any document, thereby showing that his name appeared in any of the voter list with Sonuddin Sheikh or the projected grandparents of the petitioner. Subsequent introduction of evidence without any pleadings itself goes to show that the said evidence is or are unreliable. For instance, the school certificate is issued in the name of the present petitioner, and it is her duty to bring it on record after pleadings in her written statement. It is the duty of the petitioner to name the family members of the paternal family, because it is the fact in issued to be opined by the tribunal that she is an Indian national bearing her lineage from her projected father, Sonuddin, who is an Indian citizen. Presumption is one of the tools of evidence, but the said presumption can be considered only from the facts which are proved well within four corners of the Indian Evidence Act And once a fact is proved, subsequent relevant facts can very well be presumed after drawing presumption on the basis of the facts so proved. In the present case in hand, the lineage is to be presumed from the projected father, parents of the petitioner, until and unless the petitioner is able to link herself to the extent that she is the daughter of her projected parents by cogent evidence, naming the family member. The presumption that she is the daughter of the projected parents cannot be drawn. It is a fact which is within the special knowledge of the petitioner. If there is not even a single whisper in the plain that she has her uncle, aunt named, etc., subsequent evidence cannot be accepted of the said unpleaded fact. The opinion is an impression of the tribunal formed on the basis of the consistent facts laid before it. It is not the volume of evidence, but the consistent quality of facts, keeping in view the picture of a well-knitted family, what is required to infer the lineage of a person from particular family. In WBC number so-and-so, Bijoy Das versus Union of India, decided so-and-so. The division bench of this court held that fact in issue would have to be proved by the proceeding by adducing documentary evidence which are admissible and relevant. The petitioner, as the proceeding through her son DW4, tried to prove her link through the school certificate with her projected father, which backfired when the said DW3 deposed that he cannot say as to whether the certificate was issued to the petitioner and the student referred in the certificate are the same. The plea of Mr. Soikia that the petitioner is not the daughter of late Ikram Ali, and the reason cited by the tribunal in disbelieving the said fact that the petitioner ought to have sought for the police report, in our considered opinion, is proper. The same can be expressed in the other way, that the petitioner failed to discharge her burden to show that she is not the daughter of Ikram Ali. In the written statement, the petitioner raised that the name of the petitioner has been recorded as Rohila Khatun, daughter of late Ikram Ali, instead of Ohila, daughter of Sunauddin Diwani, in the proceeding. Under such circumstances, keeping in view the mandate of Section 9 of the Foreigners Act 1946, we are of the considered opinion that the petitioner failed to establish that she is not Rohila Khatun, daughter of late Ikram Ali, and instead she is Ahila Khatun, daughter of Sunauddin Diwani, and we do not find any error apart in the face of the opinion requiring it to be interfered. That then Lordship kindly look into my WS, which details my family tree also, page 48. Annexure 6, page 48.
Yes, please read.
Your Lordship, paragraph number 3, that the respondent is a bona fide citizen of India by birth and was born and brought up at village Singimari Chor, PS Gwalpara, district Gwalpara, Assam, in the year of 1970, according to her school certificate. That Sonauddin Sheikh and Chambakwan Baba are the parents of the opposite party, and the opposite party is a literate woman. That Amatullah Sheikh and Sunaban were the grandparents of the opposite party. The respondents' grandparents have 4 children, namely Sunauddin Sheikh, Monuruddin Sheikh, and Sundanban. Let's say Monuruddin Sheikh DW2. Earlier judgment stated no pleadings, and my family tree I have given. Then next pair of my brother, sister, also fine. That there are 9 brothers and sisters of the respondent, namely Samirun Nessa, Amil Haq, Amjad Ali, Sofiul Nessa, Asimun Khatun, Rohima Khatun, so and so, so and so. That NRC also I have given, that others documentary 1966, 1970 Bhutan list, 1985 Bhutan list, my marital status, my husband's name also mentioned in paragraph 22, Petitioner's name also appeared in the voter list. I have stated and documents I have placed, Lordship. And Lordship, page 50, last but above paragraph, Lordship, page 50, regarding wrongly mentioning my father's name, that the name of the respondent and the father has been recorded as Rohila Khatun, daughter of late Ikram Ali, instead of Ahila Begum, daughter of Sonoddi Dewani, in the instant proceeding. That's I have stated also. Then my evidence also, Lordships, will find evidence part page 53. There is no cross in this case, Lordship. That's I have, which I have pleaded in my written statement, that elaborate discussion, Lordship, brother, sister, my uncle's name also. And Lordship, page 55, paragraph bottom, will find that again I have clarified that the name of mine and my father has been recorded as Rohila Khatun, daughter of Ikram Ali, instead of Rohila Begum, Sonoddi Dewani, in the instant proceeding. Lordship, then find notice, page 47. Page 47. Prior to notice, Lordship, page to regarding enquiry report, page 40. Whole case on the basis of this enquiry, Lordship, notice issued referred to the matter of tribunal, page 40. Prior copy, Lordship, type copy is the original photo certified, Lordship. Page 40, form 1, that is. Name of the person, Rohila Khatun. Father's name mentioned Ikram Ali. Marital status, my husband's name Kafiluddin. Next 41, my husband's name and 2 children's name mentioned, Lordship. And enquiry officer, page 42, Siddiq Ali. It was recorded on 70/2001. On the basis of, next page is form 2, similar like that, Lordship, written. Father's name Ikram Ali, my name Rohila Khatun. I disputed it in my pleadings. And the notice, Lordship, next page 46, type copy. My husband's name mentioned. Since my address and my husband's name, I received the notice and appeared before tribunal and contested the case, Lordship. And tribunal find, Lordship, the tribunal judgment, Lordship, will find page 65. Findings of the tribunal, Lordship, will find page 68. That is important, Lordship. May I read page 68 from the top, Lordship? Page 68, 68, tribunal's judgment, Lordship. Findings of the tribunal, that is important, Lordship. Paragraph 5. On perusal of documents, it is found that Exhibit A is the copy of the NRC of 1951 certified, where the name of Sonoddi Sheikh, son of Amanullah, aged about 22 years, and Musamma Sombok Barnesa, wife of Sonoddi, aged 14 years, recorded. But on careful perusal of the NRC, it is appeared that there is no signature of the authority who certified the same, and the same cannot be appreciated. Exhibit B is the certified copy of the voter list 1966, where the name of the Sonoddi Sheikh, son of late Amanullah, aged 45 years, and Sambhagwan Nesa, wife of Sonoddin Sheikh, aged 22 years, recorded at village Sinjimari under Sarkul Matia, the district Gwalpara. Exhibit C is the voter list of 1970 of village Singimari under Sarkul Matia in the district Gwalpara, where the name of Sonoddi Sheikh, son of late Amantullah Sheikh, aged 50 years, and Sambhagwan Nessa, wife of Sonoddi, aged 27 years, recorded. Exhibit D is the voter list of 1979 of village Singimari, where name of Sonoddi Sheikh, son of Amantullah, aged 56 years, and Sambhagwan Nessa, wife of Sonoddi, aged 35 years, recorded. Exhibit E is the voter list of 1989 of village Singimari in the district Gwalpara, where the name of Sonoddi Sheikh, son of Amantullah, aged 63 years, and Sambhagwan Nessa, wife of Sonoddin Sheikh, aged 55 years, recorded along with her other family members. Exhibit F is the voter list of 1997 of village Borbalupara under Sarkul Matia, where the name of Rohila Khatun, wife of Kofiluddin Sheikh, aged 25 years, and Kofiluddin Sheikh, son of Kuju Sheikh, aged 38 years, recorded. Exhibit G is the certified copy of the voter list of 2005, where the name of the opposite party recorded as Ohila Khatun, wife of Kofiluddin. Ohila Khatun is my correct name, Lordship. Sheikh, aged 35 years, and Kofiluddin Sheikh, son of Kuju Sheikh, aged about 45 years, recorded. Exhibit H is the land revenue paid receipt in the name of Sonoruddin Sheikh. Exhibit 1 is the school certificate of SBP Memorial HS School, where it is certified that Ohila Begum, daughter of Sonoddi Dewani of village Singimari in the district Gwalpara, was a student of class 5, and she left the school on 31/12/1981, and her date of birth as per admission register was 23/3/1970. From exhibits, that's important. From exhibits and statements of the opposite party, it is appeared that the opposite party was born and brought up at village Singimari under Sarkul Matia in the district Gwalpara. She read up to class 5 from SBP Memorial School. After attaining majority, her marriage solemnized with one Kofiluddin Sheikh of village Borbalupara, and accordingly her name is enrolled in the electoral roll of 1997 and 2005. But her name is first recorded in the voter list of 1997 as Rohila Khatun. And in the year 2005, her name is enrolled as Ohila Khatun, wife of Kofiluddin Sheikh. The opposite party also stated that her parents Sonoddi Sheikh and Sambhagwan Nessa, whose name enrolled in the electoral roll of 1966, 1970, 1979, and 1989 at village Singimari under Sarkul Matia in the district Gwalpara. The opposite party is the daughter of Sonoddi Sheikh of village Singimari, which is also proved. Though the school certificate SBP Memorial HS School, but on perusal of case record, it is seen that name of the father of the opposite party is recorded as late Ikram Ali. Lordship, may take note, Lordship, Ikram Ali. I have seen all other information recorded in the reference, which are almost correct and match with the opposite party. But the name of the father of the opposite party is not matched with the reference case record. In this relation, the opposite party in her WS has stated that in the reference case, name of her father recorded as late Ikram Ali instead of Sonoddi Dewani. But only mentioned in the WS, the late Ikram Ali is not her father, is not sufficient. The opposite party did not take any initiative to call for police report. To that effect, without having any application for police report, the tribunal cannot call for any police report to that effect. Whether the father of the opposite party is Sonoddi Sheikh or Dewani or late Ikram Ali. From exhibits and other evidence of opposite party and evidence of DW3, it is appeared that the opposite party is the daughter of Sonoddi Sheikh, Elias Dewani, and Sambhagwan Nessa of Singimari. But the opposite party failed to establish any link with late Ikram Ali, whose name recorded in the reference case as their father. As the opposite party failed to establish any link with late Ikram Ali, whose name is recorded in the reference case as the father, which leads to a reasonable doubt. Only what the tribunal found, Lordship, that since reference made in the name of opposite party and father's name is Ikram Ali, which I disputed in the pleadings as well evidence. And apart from that, this honorable court lordship earlier judgment find no pleadings at all regarding my uncle lordship DW2. That is also incorrect. There is pleadings in my family tree. Everything's I detailed statement there. In the evidence lordship page, voter list exhibit D, my father, mother, and DW2's name mentioned. Documentary I have also issued. And that's interesting lordship. After disposal of these lordships, another notice I received.
You receive another notice.
Another notice. That is page 106. Enquiry report. 106. Notice is 105. My name Rohila Khatun mentioned, husband name himself. And type copy is from 106 lordship. Original come to the photocopy lordship certified. That is page 113, 113. That is very much clear also, lordship. 113 page. My name mentioned Rohila, but I am Ohila. Here father's name mentioned late Monser Ali. Earlier one mentioned Ikram Ali. Now mentioned Monser Ali. My husband's name mentioned. My children's name in the next page mentioned. 2 children's name. 3 children's name here mentioned, lordship. Page 115 lordship will find enquiry officer is saying critically. Earlier case, he was the enquiry officer. In subsequent case, he is the enquiry officer, Siddiq. Earlier, he recorded my father's name, Ikram Ali. Subsequent inquiry, he recorded Monser Ali. So there is no inquiry at all in this case. Everything has been done behind the back. I disputed it and pleaded in my case also. The lordship find that same inquiry officer. And 116 form B lordship report of the inquiry officer. That is also same Monser Ali mentioned. On receipt of second notice lordship, after disposal of the earlier case by this court lordship, I entered APR again. That is page 120. I submitted a petition to make inquiry. Annexure 16, page 120. That is important. May I read, lordship? This case number so and so, Union of India versus respondent Rohila Khatun, alias Ohila Khatun. That the above named petitioner for the respondent of the instant case most respectfully begs to state as follows: that today, 28/6/19 is fixed for further evidence of the instant case. That the name of the opposite party's father has erroneously been recorded as Monser Ali instead of Sonuddin Diwani, alias Sonuddin Sheikh, in the form number 1 and 2, which has submitted by the inquiry officer in the time of registering the instant case. That the opposite party actual and correct name is Sonuddin, father's name, I incidentally not mentioned, actual and correct name of Sonuddin Diwani, Sonuddin Sheikh, which has been recorded in all the relevant documents. That the opposite party has highly required to police inquiry report of the concerned police station regarding the name of the opposite party's father's actual and correct name. What is the actual name of the opposite party's father, either Monser Ali or Sonuddin Diwani, Sonuddin Sheikh, and also has needed whether Monser Ali and Sonuddin Diwani, Sonuddin Sheikh is the same and the one person or not. That the opposite party also begs to state that inquiry officer neither inquired, investigated the case in presence of witnesses during inquiry, investigation, nor the officer interrogated the opposite party at her house. The instant case has been registered against the opposite party without fair investigation, giving opportunity to produce documents before the inquiry officer at any point of time to demonstrate that she is a citizen of India, not a foreigner. Moreover, the notice has been issued to her without mentioning the name of her father and without having main grounds of suspicion that the inquiry officer registered the instant false and fabricated case against the opposite party only for harassment, that the opposite party has received the copy of the notice of the instant case because the name of the opposite party's husband has been recorded as Kafiluddin, son of so-and-so, in the form number 1 and 2. The report, the inquiry officer, and also the name of the opposite party's children have been recorded as Ataur Rahman, Abdul Ajid, and Kavita Begum, which are found correct. That the opposite party previously also received a copy of notice from the Foreigners Tribunal number 5 at Gwalpara, and accordingly the opposite party appeared before the tribunal on 8/2017 at Mornoi, Gwalpara, and the opposite party contested the said case, and thereafter the honorable member FT number so-and-so at Gwalpara declared the opposite party Rohila Khatun, wife of Kafiluddin of village Borkanda, under PS Matia in the district Gwalpara, Assam, as foreigner post 1971 stream on 24/7 to 18 by FT case number so-and-so, by IMDT reference case number so-and-so, so-and-so. And the name of the opposite party has been recorded in the copy of the form number 1 and 2 of report of the inquiry officer in the said reference FT case as Rohila Khatun, wife of Kafiluddin, daughter of late Ikram Ali of village Borkanda, under PS Matia in the district Gwalpara, Assam. And where also the name of the opposite party children have been recorded as Ataur Rahman and Kavita Begum, which are found correct, except the name of the opposite party's father, late Ikram Ali, instead of Sonuddin Dewani, alias Sonuddin Sheikh, on the one and close. That thereafter the opposite party declared as foreigner by the honorable FT number so-and-so. The opposite party appeared before the honorable Guwahati High Court and filed writ petition by number this instant writ petition appeared before the honorable Guwahati High Court and filed writ petition WPC number so-and-so, and accordingly writ petition stands dismissed. That thereafter the opposite party appeared before the honorable Supreme Court of India and filed petition for special leave to appeal, and according the petition was granted. That the opposite party praised that honorable Foreign Tribunal number 5 at Gwalpara shall pass an order to call for a police inquiry report of the concerned police station regarding the name of the opposite party's father, unless the opposite party shall suffer irreparable loss and injury. Therefore, it is humbly prayed that honorable Your Honor to be pleased enough to allow this petition and pass an order to call for a police inquiry report of concerned PS and fix another date submission WS of the instant case for the ends of justice. Then the tribunal passed order, Lordship, page 123. Relieve me from the case. That here my clarify that I am the daughter, that member is same. Earlier member passed, earlier judgment opinion. Again, here is the same member passed opinion, Lordship. That is clarified. Who I am, what is my father's name? On receipt of police inquiry. Lordship, may I read this important, Lordship? Originally, the case was forwarded by the Superintendent of Police, Gwalpara SP for short, under the IMDT Act by IMDT reference number so-and-so, so-and-so, expressing doubt about the nationality of the opposite party, Rohila Khatun, daughter of late Mansur Ali, wife of Kafiluddin, of village Borkanda, under PS Matia, in the district Gwalpara, with a prayer to decide as to whether the opposite party is or is not an illegal migrant in view of government WT message number so-and-so, so-and-so. This case was transferred to this tribunal for decision as per provision of the Foreigners Act 1946. After receiving the reference, this tribunal pleased to issue notice to the proceedee to appear before this tribunal and to submit her WS written statement or evidence on affidavit to prove herself whether the opposite party, Rohila Khatun, daughter of late Asmat Ali, wife of Kafiluddin, of village Borkanda, is a citizen of India or a foreigner with the meaning of the expression foreigner as defined in the Foreigners Act 1946. Accordingly, notice was issued on 13/6/2019 to the proceedee, and the process server went to the place of residence mentioned in the reference case. As per process server's report, He went to the place where the proceeding last decided and made an interrogation about the proceeding. That he met with the proceeding and handed over the notice to her. On the next date, the petitioner Abdul Aziz Rahman appeared and filed a petition stating that opposite party's father name is recorded in the case record as Monser Ali instead of Sonuddin Dewani, alias Sonuddin Sheikh. Hence, the petitioner prays for a police report to that effect. Police report is received, where the police reported that name of the father of the opposite party is Sonuddin Sheikh and is not Monser Ali. Hence, it is clear from the police report that father name of the present opposite party is Sonuddin Sheikh and not Monser Ali. Therefore, the present opposite party who appeared in the case is hereby released from the case, and the tribunal direct the issue notice against Rohila Khatun, daughter of late Monser Ali, wife of Kapiluddin, village so-and-so, so-and-so. The Pasarba reported that he unable to find out Rohila Khatun, daughter of Monser Ali, wife of so-and-so, in the address mentioned above, failing which the processor served the notice as per order 35F of the Foreign Minister. Your Lordship will find earlier I disputed my father's name is not Ikram Ali, son of the tribunal, holding that no police report was called for. I have not taken steps. On that ground, tribunal decided case against me that since the reference made against Rohila Khatun, wife, daughter Ikram Ali. So since I have failed to link any relation with Ikram Ali, that's why tribunal passed the order against me, which I have challenged. This honorable court also finds no police report is called for whether I am the daughter of Sonuddin Sheikh or Ikram Ali. On that ground, another ground taken, I have not pleaded anything in the WS, in the evidence, but that is also incorrect. Lordship, I have read about the WS and even the evidence. So there is an error upon the face of record, and subsequent discovery of new fact is required to be reviewed. May I place some of the judgment also, Lordship, to the Honorable Apex Court in this regard. Lordship will also find in the, I challenge the judgment of this Honorable Court before the Honorable Supreme Court, Lordship, SLP. Thus, I have annexed that was disposed of, and my brother sister's name in the NRC draft final list.
Yes, please.
That NRC draft final list, I have read my brother sister's name in the WS. NRC details, Lordship will find page 94. First name Samir Hussain is my brother. My father's name Sonuddin Sheikh. That is stated in my WS. Next, in the NRC final, Lordship draft NRC final. That page 96 is the vernaculars Samir Hussain. Next, page 97, Lordship will find my mother's name, Chamakban Bawa. Right side, Lordship find Sonuddin Sheikh, my father's name. There is Sonuddin's Chamakban Bawa husband's name mentioned, Lordship. And Amjad Ali is my brother. Number 2 in 97 page, and there's subsequent page of vernacular. And next page 101, Lordship find my one of my sisters, serial number 2, Rohima Khatun. So Sonuddin Sheikh, my father's name also mentioned. SLP petition, Lordship order, SLP is page 78, Lordship. My analogous matter, my case is also tagged together, Lordships, in this case. SLP 4704 to 19, my case was. Page 78, Lordship will find. For SLP. So many cases, including one of my case, that is Lordship will find from bottom, last but 4 Lordships. Last but 5.
Just a minute. 4704.
Yes, Lordship, 4704 to 19.
Yes.
In paragraph 27, page 92, bottom, Lordship, find regarding findings of that Abdul Quddus case, Lordships.
Era
Paragraph 27, 22. I have an explosive, 92, page 92, 22. As stated above, a person aggrieved by the opinion order of the tribunal can challenge the findings opinion expressed by UFA writ petition, wherein the High Court would be entitled to examine the issue with reference to the evidence and material in the existence of its power of judicial review, premised on the principle of error in the decision-making process, etc. This serves as a necessary check to correct and rectify an error in the order passed by the tribunal. It was highlighted that there could be contradicting decisions, opinions of foreigners tribunal, even in cases of near family members, albeit contradictions can be avoided when family tree hearings are held, as is now being undertaken. In the absence of joint decision, conflict is possible, as the principle of res judicata would not apply to separate proceedings, even if against two closely related but different persons. Each case has to be strictly decided on the facts and evidence on record. Secondly, there is a possibility that only one of the near family members may have migrated to India prior to midnight of March 2024, March 24, 1977, and therefore all it was 74 that fall in a different category. Any such conflict, however, would not compel us to take a different view. In terms of the clear statutory provisions, in a given case, the person aggrieved would have liberty to invoke writ jurisdiction, or if necessary, review jurisdiction before the High Court or this court to ensure that no injustice is done. Any order passed in case of close family members subsequent to adjudication order determining the citizenship status of a person would necessarily be a material evidence which can be duly taken note of and considered while deciding a writ petition or a review application. Here is the case losses subsequent inquiry. Subsequent case specifically stated, I am the daughter of so and so, inquiry. Tribunal earlier only on that ground my case was opinion passed against me, lordships. And may I place the decisions of the review, lordships, the Board of Control of Cricket India, lordships, Board of Control for Cricket India, to AIR 2005 or 2005 Code SCC, 2005 Code SCC 741. Board of Control for Cricket India versus Netaji Cricket
what are the
Club.
relevant paragraph?
Paragraph 89, 90, 91, 92. 89, may I read, lordships?
89, 90, 91, 92.
92, lordships. 89, Order 47, Rule 1 of the Court provides for filing an application for review. Such an application for review would be maintainable not only upon discovery of a new and important piece of evidence, or when there exists an error apparent on the face of the record, but also if the same is necessitated on account of some mistake or for any other sufficient reason. Thus, a mistake on the part of the court, which would include a mistake in the nature of the undertaking, may also call for a review of the order. An application for review would also be maintainable if there exists sufficient reason therefore. What would constitute sufficient reason would depend on the facts and circumstances of the case. The word sufficient reason in Order 47, Rule 1 of the Court is wide enough to include a misconception of fact or law by a court or even an advocate. An application for review may be necessitated by way of invoking the doctrine actus curiae Nimemi Rebabit. It is true that Moran Bar Boselius Catholics and another Barsa the most Rebelar Mar Polos Antonis and others 1991 SCR 520. This court made observation as regard limitations in the application of review of its orders taking. Before going into the merits of the case, it is as well to bear in mind the scope of the application for review, which has given rise to the present appeal. It is needless to emphasize that the scope of an application for review is much more restricted than that of an appeal. Under the provision in the Travancore Code of Civil Procedure, which is similar in term of Order 47, Rule 1 of our Code of Civil Procedure, 1908, the Court of Review has only a limited jurisdiction circumscribed by the definitive limits fixed by the language used therein. It may allow a review on 3 specified grounds, namely discovery of new and important matter or evidence, which after the exercise of due diligence was not within the applicant's knowledge or could not be produced by him at the time when the decree was passed. Mistake or error apparent on the face of record, and for any other sufficient reason, it has been held by the Judicial Committee that the words any other sufficient reason must mean a reason sufficient on grounds, at least analogous to those specified in the rule. But the said rule is not universal. Then 92. Yet again, in Lily Thomas Supra, this court has laid down the law in the following terms. Paragraph 52 referring. The dictionary meaning of the word review is the act of looking, offers something, again with a view to correction or improvement. It cannot be denied that the review is the creation of a statute. This court in Patel Narsi, Takershi versus Pradhyuman Singh Ji or Arjun Singh Ji, AIN 1970, Supreme Court 1273, held that the power of review is not an inherent power. It must be conferred by law, either specifically or by necessary implication. The review is also not an appeal in disguise. It cannot be denied that justice is a virtue which transcends all barriers, and the rules or procedures or technicalities of laws cannot stand in the way of administration of justice. Law has to be bent before justice. If the court finds that an error pointed out in the review petition was under a mistake and the earlier judgment would not have been passed but for erroneous assumption, which in fact did not exist, and its perpetration shall result in miscarriage of justice, nothing will preclude the court from rectifying the error. Then I am relying on the decision lawsuits of the Honorable Apex Court 1993 supplementary. 1993 supplementary 4 SCC. 4 SCC. Page 595. Paragraph 18, 19, 20. May I read, Lordship? Paragraph 18. Justice is virtue which transcends all barriers. Neither the rules of procedure nor technicalities of law can stand in its way. The order of the court should not be prejudicial to anyone. Rule of stare decisis is adhered for consistency, but it is not as inflexible in administrative law as in public law. Even the law bends before justice. Entire concept of writ jurisdiction exercised by the higher court is founded on equity and fairness. If the court finds that the order was passed under a mistake and it would not have exercised the jurisdiction, but for the erroneous assumption which in fact did not exist, and its perpetration shall result in miscarriage of justice, then it cannot on any principle be precluded from rectifying the error. mistake is accepted as valid reason to recall an order. Difference lies in the nature of mistake and scope of rectification, depending on if it is of fact or law. But the root from which the power flows is the anxiety to avoid injustice. It is either statutory or inherent. The latter is available where the mistake is of the court. In administrative law, the scope is still wider. Technicalities apart, if the court is satisfied of the injustice, then it is its constitutional and legal obligation to set it right by recalling its order. Here I explain the bench of which one of us, so was a member, did commit an error in placing all the stipendiary graduates in the scale of first division assistants due to state failure to bring correct facts on record. But that obviously cannot stand in the way of the court correcting its mistake. Such inequitable consequences as have surfaced now due to both affidavit filed by the state cannot be permitted to continue. Then paragraph 19. Review literally and even judicially means re-examination or reconsideration. Basic philosophy inherent in it is the universal acceptance of human fallibility. Yet in the realm of law, the courts and even the statutes lean strongly in favor of finality of decision legally and properly made. Exceptions both statutorily and judicially have been carved out to correct accidental mistakes or miscarriage of justice. Even when there was no statutory provision and no rules were framed by the highest court indicating the circumstances in which it could rectify its order, the courts called out such power to avoid abuse of process or miscarriage of justice. In Raja Pitti Chand Lal Chaudhary versus Shukraj Rai, the court observed that even though no rules had been framed permitting the highest court to review its order, yet it was available on the limited and narrow ground developed by the Privy Council and the House of Lords. The court approved the principle laid down by the Privy Council in Rajendra Narayan Rao versus Bajaji Govind Singh that an order made by the court was final and could not be altered. Nevertheless, if by misprision in embodying the judgments by errors have been introduced, this court possess by common law the same power which the courts of record and statute have of rectifying the mistakes which have crept in. The House of Lords exercise a similar power of rectifying mistakes made in drawing up its own judgments, and this court must possess the same authority. The Lords have, however, gone a step further and have corrected mistakes introduced through inadvertence in the details of judgments, or have supplied manifest defects in order to enable the decree to be enforced, or have added explanatory matter, or have reconciled inconsistencies. Basis for exercise of the power was stated in the same decision as under. It is impossible to doubt that the indulgence extent in such cases is mainly owing to the natural desire prevailing to prevent irremediable injustice being done by a court of last resort, where some accident without any blame, the party has not been heard, and an order has been inadvertently made as if the party had been heard. Rectification of an order thus stems from the fundamental principle that justice is above all. It is exercised to remove the error and not for disturbing finality. When the Constitution was framed, the substantive power to rectify or recall the order passed by this court was specifically provided by Article 137 of the Constitution. Our Constitution makers, who had the practical wisdom to visualize the efficacy of such provision, especially conferred the substantive power to review any judgment or order by Article 137 of the Constitution. The clause C of the Article 145 permitted this court to frame rules as to the condition subject to such any judgment or order may be reviewed. In exercise of this power, Order 40 had been framed, empowering this court to review an order in civil proceedings on grounds analogous to Order 47, Rule 1 of the Civil Procedure Code. The expression for any other sufficient reason in the clause has been given an expanded meaning, and a decree or order passed under misapprehension of true state of circumstances has been held to be sufficient ground to exercise the power. Apart from Order 40, Rule 1 of the Supreme Court rules, this court has the inherent power to make such orders as may be necessary in the interest of justice or to prevent the abuse of process of court. The court is thus not precluded from recalling or reviewing its own order if it is satisfied that it is necessary to do so for sake of justice. So my case, lordships, is here. There is an error apparent. Totally, I find this error regarding family tree pleadings. My uncle's name also stated in the exhibit A also. And subsequent inquiry tribunal clarified. Earlier tribunal found that since reference is made my father's name Ikram Ali, my document related to Sonoddi Sheikh. So there is a difference. That's why that opinion is given against me. This honorable court, while deciding the case, stating that no family tree, no pleadings at all, that is not correct at all. Lordships have seen. And apart from that, also stated no police report called for regarding whether I am the daughter of so and so. But in subsequent notice, same inquiry officer, same tribunal clarified. Inquiry officer stated another father's name. Earlier, Ikram Ali, second one, Samsur Ali. But when police would call for clarified that I am the daughter of son of this, and tribunal also released me. So my humble submission is that that order may be recalled and remand the matter to the tribunal for fresh decision, lordship, by referring the both inquiry report. This is my humble submission.
Yes.
My lord, the ground for review, the petitioner has cited, my lord, mainly on
See,
two.
basically, the petitioner has filed this review petition after the order passed the case of Abdul Quddus by the Honorable Apex Court.
Yes, I'm
Now-
coming to that point.
Pointing out the relevant paragraphs of the Abdul Quddus.
Yes.
The petitioner stated that he has the right to prefer this review petition.
That is a different aspect, my
And
lord.
now, third clause is that in a subsequent proceeding,
Yes,
the fairness tribunal, the petitioner's name, father's name has been corrected. And so, since this is a subsequent finding, and his case, her case should be considered. So the order passed by the coordinate bench of this court to review.
I'm coming to all these points, my lord.
Two more things. That the coordinate bench at that point of time considered the fact regarding the school certificate and the DW2 when would be his uncle. Our
Yes.
uncle,
That's right.
and it was not specific.
Yes.
These are his points.
Yes,
Anything else?
nothing.
Mr.
First of
Gordon,
all-
you have cited two judgments,
Yes,
CCCI and the other matter.
Yes, yes, sir.
My lord, first ground, according to him, my lord.
Okay.
uh,
You are
as per-
talking, you are leading us to the ground.
Yes. There are page 12, my lord.
Hmm.
His, my lord, first ground is that whatever he submitted and my lord, evidence produced, those were disbelieved. And so those has to be believed. And that is, those were disbelieved by the tribunal and the high court. That's why those are error apparent. Can it be, my lord? Because he has said, my lord, he has given a statement. Quoted in the instant case, there is inquiry. There was no inquiry. Inquiry officer, so-called inquiry report prepared the inquiry officer in so and so. Thereafter, your lordship will find in the last paragraph, he has given the facts, my lord. Further in the petitioner, accordingly, police made an inquiry and found the petitioner is the daughter of late Sunwar Uddin Diwani alias Sunuddin Sheikh, but the learned tribunal as well as the honorable court disbelieved the petitioner's pleadings as well as evidence which are error apparent on the face of the record. Disbelief is not an error apparent, man. It is the discretion of the court, discretion of the tribunal. Tribunal, whatever found, my lord, and the High Court, whatever found in the earlier proceeding, they have recorded, and accordingly that has been opinion or the judgment has been given. Disbelief is not an error apparent. What is the error apparent? According to him, it is court disbelieved the my lord submission submitted by the petitioner. That cannot be a ground of my lord review. Second ground is that, my lord, when the second ground is that the Monuruddin, my lord, according to me, last, my lord, second ground in the last part, my lord. Yes, it's exhibit A along with her parents, but while deciding the matter,
C or B?
my lord, B, my lord. Monuruddin, my lord, page 13, my lord. Monuruddin as DW2. Monuruddin appeared as a DW2, my lord. To prove the school certificate, she testified DW3, who is the UDA SP Memorial High School, son of so-and-so. DW4 altogether petitioners. And her pleadings of evidence, DW2, Monuruddin is her paternal uncle, and having the school certificate herein, her father name appeared and the name of the DW2 appeared in annexer exhibit A, along with the parents, but while deciding the matter, this honorable court held that there is no pleading at all. The DW2, Monuruddin is the paternal uncle, and the petitioner was the student of SBP Memorial SS School, which is an error apparent on the face of the record. This is not correct, madam. There is no pleading. In fact, I can show your lordship. There is no pleading at all. There is no pleading at all, my lord. To this effect, your lordship.
See, what the tribunal and the court found, though the proceeding in her written statement stated that there are 4 brothers of her father and one is Monuruddin. Now, the tribunal and the court found that there is no such evidence to show anything.
No,
Did
my
not
lord.
place any evidence to
My
show
lord.
that any such voter list
Yes.
showing himself with the father of the petitioner.
Yes, my lord. That is not there.
And it was, since it was not there, that part of the submission made by the petitioner that Monuruddin is her uncle
Uncle.
was disbelieved or not accepted.
Yes, my lord. That was not supported by any.
That is the reason.
Yes, ma'am. And thirdly, for that case, his case is that, my lord, the second proceeding.
Now we'll come to the second proceeding later.
Yes.
Now, one by one. Now,
My-
the school certificate.
Yes. School certificate was, it is clearly discussed by the High Court, my lord, why it is not accepted. So if they are not satisfied with that finding, they can go for appeal. Definitely, my lord. They can go for appeal. I have no objection on that. But it is not a ground of review to reappreciate, to take another view. My lord, I have read out the Kamalesh Burma judgment today morning. It is clearly said, my lord. The view, in fact, Lily Thomas also, it is clearly said, my lord, that if the, my lord, the petitioner is not, my lord, does not accept the view of the High Court, they can go for appeal. And in this case, appeal was filed. But what, my lord, in fact, my submission is that in that Abdul Quddus was filed, and they, I don't know, they have taken together the matter. That case was filed for giving an opportunity to the persons who have been declared foreigner to file an appeal in the, my lord, NRC tribunal. That was the original claim. Their submission was that in the Foreigners Act, 1946, there is no provision of appeal. So they are taking the, my lord, benefit of 226. But in NRC proceeding under 2003 rules, there is a appellate provision. In the Honorable Apex Court, they submitted that though we have been declared in foreigner, but as there is a provision under NRC rule 8, my lord, so we may be given opportunity to appeal before the tribunal.
But
That was negated by the Honorable Apex Court in this Abdul Qud, in this present case itself. In the last line, your lordship will find their claim has been rejected. Their claim is rejected, my lord. In the judgment itself, my lord, your lordship will find para 19, page 93, my lord. Page 93.
para 26.
Yes, para 26. If your lordship may kindly see from para 24.
26.
Yes, 24 onwards, my lord. In view of the aforesaid findings, it has to be held that paragraph 8 of the schedule to the 2003 rules, which gives the right to appeal before the tribunal under 1964 order, would apply only if and in those cases where the tribunal constituted under 1964 order has not already educated upon the decided the issue as to whether the person is an Indian national or foreigner. If, my lord, the 64 foreigners under the NRC rules, my lord, if the person name has been, my lord, deleted, or his name is not accepted in the NRC process, he can go for appeal under the Foreigners Tribunal, under the NRC rule 2003. But if the person is already been declared by the foreigner, by the Foreigners Tribunal, he cannot go for appeal. That is the rule, and that is affirmed by this. Then para 25, my lord, alternative submission that the court should create an appellate forum. That was negated by the Honorable Apex Court. They are praying is that, then create an alternative forum for those persons who have been declared foreigner by the Foreigners Tribunal. Appellate forum has not been pressed in the written submission and argument. We would not give any such direction and entrance upon the field of legislation reserved for legislature. This is not a case of unoccupied legislation, nor would facts justify the court to exercise power, as in the case of vacuum, and when there is complete absence of active law to provide the effective enforcement of basic human rights. With the aforesaid observation, madam, now we dispose of this appeal and reject the contention of the appellants on the perceived conflict pertaining to the adjudication on the citizenship status of person. Their claim has been rejected. We also reject the contention that this court should direct the creation of an appellate forum. And prior to that, what is their claim, my lord? On what basis they are coming to this honorable court by filing this review petition? On the basis of para 23. What para 23 says, my lord? Para 23 says, it was highlighted that there could be a contradicting decisions, opinion of Foreigners Tribunal, even in case of near family members. Albeit contradiction can be avoided when family trees hearing are held is now being undertaken. In the absence of joint decisions, conflict is possible as the principle of res judicata would not apply to separate proceedings, even if against two close related but different persons. As each case has to be strictly decided on facts and evidence on record. Secondly, there is possibility that someone of the near family members may have migrated to India prior to midnight of 24 March 1971 and thereafter fell in different category. Any such conflicts, however, would not compel us to take a different view in terms of the clear statutory provision. In a given case, this is the point, in a given case, the person aggrieved would have liberty to invoke writ jurisdiction. They can invoke writ jurisdiction, or if necessary, review jurisdiction before the High Court or this court to ensure that no injustice is done. This is the only point on the basis of which they are coming. They have not given any right, my lord, that you go and file a review for this. It is said, in a given case, my lord, the person aggrieved would have liberty to invoke jurisdiction if he has liberty to invoke jurisdiction of writ jurisdiction, or if necessary, review jurisdiction before the High Court or this court to ensure that no injustice is done. Any order passed in case of close family members subsequent to the adjudication order determining the citizenship status of person would necessarily be a material evidence on which can be duly taken note of the consideration when deciding the writ petition or review application. So this is, my lord, said any order passed in case of close family members. Who is that close family members? There is no decision of any honorable any court or any tribunal. Subsequent to adjudication or order determining the citizenship status of person would necessarily be a material evidence which can be duly taken note of considering there is no adjudication of any family member subsequent to this. And what the I
So
submitted.
you want to say, though the petitioner has taken the cue from this Abdul Quddus,
Yes, ma'am.
more particularly para 23,
Yes.
and giving precisely on this particular sentence in a given case. So wherever there was already a decision by the tribunal and the court, with regard to those cases, license was not given to such proceedings to file review.
Review, ma'am.
You are saying that they did not direct.
Yes, ma'am.
So it has an option in a given
Yes,
case.
it's an option.
They has file a review. That, but this doesn't
If-
mean that you go and file review.
Go and file review. There is no direction as such. There is no direction as such.
So
They have
had
been
the
given,
option.
they have the option. If they want to
If
review,
they had
file a review.
obtained the option, at that point of time, it is
Yes,
fine.
yes,
Not
ma'am.
obtained, not proceeded or not taken that option.
Yes, my lord, that is a difference. And secondly, my lord, secondly, it is said any order passed in close family members, any order passed in case of close family members subsequent to adjudication order determining the citizenship status of person would necessarily be a material evidence. There is no order passed by any authority to his my lord relative or her relative
So
subsequent to this opinion.
according to you, there was no such decision.
Yes.
By any such authority declaring our immediate
Relatives.
family members or relatives.
Yes.
Saying that they are
Citizen of.
citizens.
Oh, there is no question. And now, my lord.
Why
se-
you are saying it?
No, second, my lord, because the NRC documents, my lord, which now they are claiming NRC, our brother's name, my sister's name, my father's name, my brother's name is appearing, so I am also Indian. The NRC is not yet finalized. NRC,
That remains with the NRC.
NRC.
What about the decision taken by the tribunal in the second case?
no, second case, it is not yet, my lord, it is declared foreigner. The person, whether it is the same person or we don't know, because she is not appearing. She is hiding from the proceeding. Now she is saying, my lord, she is hiding from the proceeding. We cannot say. Your lordship may kindly see the second proceeding. What is the
The
finding?
second proceeding whose father
Yes,
was wrongly according to the proceeding, the
Yes.
notice it was issued in the name of another person. And
Rohila Khatun,
daughter of.
daughter of Monser Ali.
Both cases
Now,
wrongly
she did
recorded.
not appear,
Both cases.
right? Now, for her, daughter of Mansur Ali, she has been declared a foreign.
Yes,
What the petitioner is saying, that during police inquiry, it was found that it is not Rahela Khatun. That part.
your lordship may kindly read that person. It is not the against the petitioner. On the next date, the petitioner Abdul Aziz Rahman, para 3, my lord.
Page number,
124, my lord.
Ah.
124, para 3, my lord. Accordingly, notice was issued on 13/6/2019 to the proceedee and process server went to the place of residence mentioned in the reference case. As per process server report, he went to the place where the proceedee last resided and made an interrogation about the proceedee, and he met with proceedee and handed over the notice to her. Now, on the next day, the petitioner, this is Abdul Aziz. Who is that Abdul Aziz? We don't know. Abdul Aziz Rahman appeared and filed a petition stating that opposite party's father name is recorded in the case record as Mansur Ali instead of Sonuddin Dewani, alias Sonuddin Sheikh. Hence, the petitioner pressed for police report to the fact. The police report is received where the police reported that the name of the father of the opposite party is Sonuddin Sheikh and not Mansur Ali. Hence, it is clear from the police report that father name of the present OP party is Sonuddin Sheikh, not Mansur Ali. Therefore, the present opposite party who appeared in the case is hereby released. This person is released. is released from the case and the tribunal direct to issue notice against Rohila Khatun, daughter of late Mansur, wife of so-and-so under section so-and-so, so-and-so, so-and-so. 64. The process server report that the unable to find the Rohila Khatun, daughter of so-and-so, address mentioned above, pending which the process server served the notice as per so-and-so, then she has been declared foreigner. We don't know whether this is Rohila Khatun or Ahila Khatun, my lord. The observation is against one Abdul Aziz, and he has been released from that proceeding. This hide and seek game will not play, my lord. The person who did not appear in the tribunal and coming here saying that no, I'm not that person, my father name is different, and she is not participating in that proceeding. Where is she?
Have you challenged?
We are not challenging. Why should we challenge? And she will come here and say, see, here this order, this is this. This is declared foreigner. Where is she? This is totally different lady. And she has not stated that she had a proceeding and where she has been declared foreigner. She has not went before the tribunal to contest that case. And now saying, no, this Rohila Khatun is me. I was not Ahila Khatun. So I have been here, my father name is different. So there my father name is wrong. She's claiming that she should come with fair hand. She's not coming with clean hand. And in review jurisdiction, we have this noble court, my lord. Can we see that? She has not challenged that. If she is challenging that repetition, my lord, that order, that is a different issue. He cannot take benefit of this opinion, my lord. Annex 7. Mere saying that my father name is different in that case, the tribunal has decided on the basis of materials available on record. Second, firstly, my lord, the school certificate. The school certificate was not, my lord, that pleading was not there at all. Neither in the WS nor in the evidence. She has not stated that she was reading in some school and she has any certificate, school certificate.
No, she has mentioned. She
No
has
one.
mentioned if you come to
Everything professional.
the WA, what she has mentioned?
WS page 53, my lord.
She has mentioned,
No.
please come to page number 48.
Portray the instant proceedings beyond cause of action.
Para
Paratree. The born of a citizen of India and brought up in the school and Assam in the year.
that much.
Yes,
But she
that
did
was
not
only.
state
She has not stated, my lord. She
in which
went
school
to the
she
school.
studied, where she had gone, she did not mention. Only left it.
Yes, she was
In
born and
Bhegua.
brought up in the village in Assam in the year 1970, according to her school certificate.
That much.
Is it? It is. My lord, what is the statement? According to skill certificate, her date of birth is 1970. That is a vague statement. And in evidence also, she has stated that much only. Evidence page 53, my lord. 1970, her date of birth is 1970 as per the school certificate. Which school certificate? When did she went to school? Which school she went? Nothing is there, ma'am. And the police inquiry, even though, my lord, we accept that there was a police inquiry and that father name is different, and that is not a conclusive. That they cannot take that, my lord, advantage. It's on the basis of, my lord, information given by them only. In fact, my lord, there is no other ground. These are the only grounds. And as per my humble submission is that, my lord, these grounds are not grounds for review. Review, we should go furthermore, my lord. I have submitted today morning the judgments of this honorable apex court, my lord. In fact, CPC also clearly says, my lord, CPC order 47 rule 1 says, my lord, on what ground review can be filed. It is clearly said. The review can be filed from the discovery of new and important matter or evidence which, after the exercise of due diligence, was not within the knowledge or could not be produced by him at a time when the decree was passed or order made, or on account of mistake or error apparent on the face of the record, or for any other sufficient reason desires to obtain a review for the decree passed or order made against him. So that has been, my lord, again and again, the honorable apex court explaining this same, my lord. Numbers of judgments where it is said, my lord, the review petition is a not hearing of original petition or original case. And it cannot substitute the view, my lord. Once the original court taken a view, that cannot be substituted by the, my lord, review in review. I have relied on Formales Verma, my lord, today morning. 2013 HSCC 320. I would like to read out 2-3 paragraphs of that, my lord.
2013.
2013 HSCC 320. Just I would like to read out, my lord, the para 14 onwards. At note of, yes, ma'am. Para 14. Review of earlier order cannot be done unless the court is satisfied that material error manifest on the face of the order undermine its soundness or reasonableness and miscarriage of justice. That is under para 14. My lord, the honorable apex court has relied on the earlier judgment of the honorable apex court. Then another point, my lord, point number 15, para 15, it is said, an error which is not self-evident and has to be detected by a process of reasoning can hardly be, as said, hardly be to be an error apparent on the face of the record, justifying the court to exercise its power under review. And error apparent should be, my lord, apparent. It cannot be like that. It should be fished out by giving some reasoning, this, that. Then only review is like review license. Then it is also there. Also, the honorable apex court has relied on earlier judgment of the apex court, my lord, numbers of judgment. Then it is said, para 16, my lord, error contemplated under rule must be such which is apparent on the face of the record, and not an error which has to be fished out and searched. It must be an error of inadvertent. The power of review can be exercised for correctness of mistake, but not to substitute a view. It's not for substitution of a view, my lord. The mere possibility of two views on the subject is not a ground for review. The Lily Thomas has been, my lord, quoted here in this para 16. Then para 17 says, my lord, in a review petition, it is not open to the court to reappreciate the evidence and reach a different conclusion. We cannot reappreciate the evidence and come for a different conclusion, even if that is possible. Even if that is possible, well, a review court is not going to do that. Conclusion arrive at the appreciation of evidence cannot be assailed in the review petition unless it is shown that there is an error apparent of the face of the record. This honorable court has given conclusion after examining all the records and evidences and after going through the records, and it cannot be reopened. Then para 18 says review is not a hearing of the original matter, so it cannot be said, my lord. Then para 19 says, my lord, review proceeding are not by way of appeal and have to be strictly confined to the scope of an ambit of Order 47 Rule 1 of the CPC. So Order 41 Rule 1, Order 47 Rule 1 clearly says when review lies, my lord. So this has been naturally given in my lord, para 20.1 and 20.2. Everything has been, my lord, shortly discussed. So in the case, my lord, present case, the petitioner has, in fact, the petitioner wants the writ petition to be heard. In fact, the opinion of the tribunal may be reappreciated, and it may be heard again. They could not point out, my lord, anything which is error apparent on the face of the record. What the third point, my lord, that the documents, my lord, second opinion where the Rahila Khatun is not the daughter of, my lord, Ikram Ali. Those things are not, my lord, review jurisdiction. Those things cannot come under review jurisdiction.
Kindly repeat the last part again.
My lord.
Those cannot come under.
No, my lord, what my lord friend is, my lord, relying on the second second proceeding, one against one Rohila Khatun, daughter of my lord Monser Ali, wife of Kafiluddin, is, my lord, cannot be relied on by the petitioner in the instant case, because that cannot come under review jurisdiction, my lord. It's not a new documents or new evidence. This is totally of, my lord, if this is to be relied on, my lord, we have to fish out everything. This is not an error apparent. This is not a new document which is, my lord, directly relevant to the petition. Relevancy of this document is very much, because here is Rohila Khatun, there is Ahila Khatun, father name is Mansur, Kafiluddin. All this, if we have to believe these things, my lord, we have to fish out each and every one. This is not apparent. Further, my lord, from the order is wanted to itself. It is clear that, my lord, the dispute was not against the dispute which my learned friend is arguing, that my father name is not that, my father name is this. That was not against, with regard to the Rohila Khatun or Ahila Khatun. That was against one, my lord, this is Abdul Aziz. Abdul Aziz, this decision is against Abdul Aziz, that Abdul Aziz is not the, my lord, son of Monser instead of son of Din Diwani. And hence, he has been released from the proceeding. So this will not help the petitioner in review jurisdiction. Because nothing materials of the petitioner is, my lord, recorded in this order. whether she is the daughter of Mansur Ali or Akram Ali, whether she is the wife of Malad Kafiluddin, and whether she studied in the school, whether she was a resident of that area. Nothing has been come out from this record, Malad, from this document, because she has not participated in this proceeding. We don't know whether this is the same lady or not. And in the record, there is in this judgment, this opinion, my lord, 9/8/2019, there is no whisper that the Rahila Khatun, she earlier participated in a proceeding wherein she has been declared foreigner or Indian. There is no evidence to that effect. Nothing reveals from this order. One thing more, my lord, with regard to the NRC documents, my submission will be, my lord. Even though a person, if they want to take the benefit of Para 23 of the Abdul Qudus, my lord, then she has to prove that she is the brother or daughter of that person who is not an foreigner or who has been declared citizen of India. That fact has to be proved. Then only she can get the benefit of Para 23. Suppose a person has been declared for Indian, my lord. Suppose A has been declared Indian. If I want to get the benefit of that opinion, I have to prove that yes, I'm the brother or I'm the daughter of that A. Unless it's until I prove that I'm the brother or sister or daughter of that person, my lord, that cannot be. I cannot take benefit of that order. So in the instant case, my lord, if the petitioner's case was in the tribunal, she has failed to establish that she is the daughter of that person who is not a foreigner. She has failed to establish that the Malad whose names are there in the NRC or brothers and sisters, they are her brothers and sisters. She has not given anything to that. As she failed, this honorable court has declared, the tribunal has declared him foreigner. What she has proved in the tribunal, my lord. Mere saying that my brother is a Indian and his name is in NRC, that will not do, my lord. If she has proved in some time at the time of my lord proceeding that yes, A is my brother and he has been now my lord in the NRC, he is in NRC, that's a different issue. Then she may come for review jurisdiction. Yes, in the tribunal proceeding, I have proved that A is my brother or A is my father, but now her name or his name is in the NRC, so she is an Indian, so I should get the benefit of that. That is a different issue. But if she has not proved that fact that I'm the daughter or I'm the brother of that person, and now his name is in the NRC, she will not get the benefit of that NRC. In fact, the NRC is not yet finalized, however. So, under such circumstances, my lord, my humble submission is that, my lord, this review is not maintainable, as there is the grounds are not, my lord, sufficient for review of the order, judgment or judgment and order of this honorable court, earlier judgment and order of this court. My lord, the later on also this honorable court has in another judgment considered the Kamalesh Verma in
So
2022
according to
as
you, that these grounds specified by the petitioner in these review petitions doesn't cover the grounds specified in the Kamalesh Verma.
no, ma'am. In fact, first one is, my lord, the first, as I have submitted, they
Disbelief.
want the, my lord, another view may be taken by this honorable court,
Disbelief.
disbelief. So this honorable court should believe and take another view of this view on that point.
That's not error.
Who is,
apparent.
that is not an error apparent. And we cannot take another view, my lord. Taking another view is not a purview of the review jurisdiction, my lord.
Anything else? Any further?
No. Then second point, as I have argued, my lord, second point, his point was that my lord mentioned details about my lord, schools, school certificates. These were disbelieved by this honorable court. But this honorable court has clearly said, my lord, observe all these things.
No, court found
Yes,
that DW3
yes, DW3. which
sometimes
you-
in April 2017
Yes,
brought a school certificate.
yes. It is clearly said, my lord. In fact, page 74, my lord, there in fact, page 76, my lord. There it is clearly stated. The court, why this honorable court rejected, until and unless the petitioner is able to link herself to an extent that she is the daughter of projected parents by cogent evidence naming the family members, the presumption that she is the daughter of projected parents cannot be drawn. My lord. That's why the honorable court has rejected his claim, my lord. In fact, that the school certificate was not introduced by the petitioner. It was introduced by the son of the petitioner, my lord.
And
And
recorded there.
yes, it is recorded.
DW3.
Yes, DW4, DW4, my lord.
3 is that school UGA.
Yes. And DW2, in fact, did not, my lord, what this deposition did not rely on any documents, thereby showing that the name appeared in any of the voter list with Sonauddin Sheikh or the projected grandfather of the petition. The DW2, who has come as an uncle, he could not produce any documents. By where, my lord, he himself linked with the father of the petitioner or grandparent of the petitioner.
Has been pointed out.
Yes, those are pointed out, my lord. So it is not that those are not considered. And the pleadings were, if even though he has pleaded, my lord, 70, his father was, her date of birth is 70 as per the voter, my lord, school certificate. That is totally vague statement. Well, this honorable, the honorable apex court recently in 2022, my lord, would, considered the review jurisdiction. My lord, again, my lord, the Kamalesh Burma has been reaffirmed and said it cannot be, my lord.
Just
This is
number, give the number.
2022 SCC online, my lord. 2022 SCC online SC 1034.
SC 1034.
Yes, madam. This is civil appeal number 5503 04 of 2022, madam.
5503/04.
No, 03-04, madam. Both 03 and 04 of 2022, madam. S. Madhusudan Reddy versus Narayan Reddy. In para 24, the
SCC online. Point. Zero three. Eight. Good enough.
Para 24 it is considered everything. Then para 33, 32 also, my lord.
Yes. Para
24 months. The Kamala Burma, points of Kamala Burma has been reiterated.
anything, any proposition here?
Manoj, Manoj, only your lordship may kindly produce para 40, my lord. Some interesting fact, interesting issue is there. Just quickly. There, my lord,
You have mentioned 24.
yes, para 24, my lord. 24, 27. This is a reformation of earlier judgment. 28, my lord. 29, 30, all discuss the earlier judgment of this honorable apex court.
Then you say it is 40.
40, my lord. 40, my lord. This is some interesting facts that you have. In our opinion, even otherwise recourse to successive review petitions against the same order is impermissible. More so, when the respondents have miserably failed to draw the attention of this honorable court to any circumstance that had entitled them to invoke review jurisdiction within the ambit of the rules. Under the rules, the respondent were not required to produce genuine documents, but new documents, evidence that was not within their knowledge and could not have been so even after exercise of due diligence, which could have turned the tables in our favor. But in the case, my lord, they have submitted earlier they have submitted Xerox copy of the receipt, my lord. Later on, they were trying to submit the original copy, genuine copy. So that is not permissible in because the law says, my lord, new evidence, genuine documents, but new documents or evidence that was not within the knowledge and could not have been so even after exercise of due diligence. It should be new documents or new materials, new evidence, which could not be produced even after due diligence.
Anything else?
That's all, my lord.
Yes, Mr. Barboya. What did you reply?
My learned friend always in confusion. Lost. Firstly said because Abdul Quddus I came now. That is statute provides lost. Order 47 rule. Order 47 rule 1 statute provides. A person to me. In this case, petitioner preferred appeal.
As per
SL
order 47, what is the finding? Tell us.
Yes,
What you have found?
yes. Order 47 rule lordships
Which
says
11 provision.
application for review of judgment. Any person considering himself aggrieved by a decree or order from which an appeal is allowed, but from which no appeal has been preferred, by a decree or order from which no appeal is allowed, or by decision on a reference from a court of small causes, and who from the discovery of new and important matter or evidence which, after the exercise of due diligence, was not within his knowledge or could not be produced by him, at the time when the decree was passed or order made, or on account of some mistake or error apparent on the face of record, or for any other sufficient reason, desire to obtain a review of the decree passed or order made against him, may apply for a review of judgment to the court which passed by decree or made the order.
Tell us,
That is, yes, Lordship,
what is
first,
the ground here? Which
yes,
ground?
ground
There was an
number,
appeal provision, you did not prefer appeal, that is the ground why you have preferred a review.
there is a,
Or with due diligence, you did not receive anything earlier, for which reason?
here is the case, Lordship. First of all, tribunal judgment, tribunal held that reference is made Rohila Khatun, daughter of Ikram Ali. No police report was called for whether Rohila Khatun is the daughter of Ikram Ali or not. But petitioners proved that Rohila Khatun proved she is
Mr.
the
Bhavna, just tell us one thing. The first case, inquiry and everything was under the IMDT,
Lordship.
Right.
Lordship.
all inquiries.
Lordship.
The reference was under the IMDT.
Lordship.
This was pending before the IMDT tribunal, right? Then the judgment of the Sarvanda Sunwal won,
Lordship.
pursuant to which all the pending cases before the IMDT transferred to the foreign state.
Lordship.
Now, when the IMDT Act was struck down, if you read the Sarvanda Sunwal, you will see, though the state argued for the act, but the Honorable Apex Court found that when there is a specific provision, if somebody was considered to be a foreigner, Section 9, read the entire judgment, you will see how the
Yes.
Honorable Apex Court has dealt with it.
Lordship.
And the burden is on the proceed.
Proceeding.
How come the state can bring an act giving the burden on the state to prove that he is an illegal migrant? The Honorable Apex Court had discussed those issues
Lordship.
and thereafter finding how he also discussed
Lordship.
why this illegal migrant is just like in war.
Lordship.
Hereafter finding these provisions have declared and
Lordship.
struck down the IMDT. Now, once the IMDT has been struck down as an illegal act, any such inquiry made during the course of the IMDT Act and on the basis of which there was a pending before the IMDT tribunal, those inquiries, do you rely on those inquiries? Because those inquiries, when the act has been struck down, rules have been automatically will go. Any inquiry made under IMDT Act will also go. But the specific is that since the matters are pending before the IMDT tribunal, which is no longer in force, all those matters pending before the tribunal shall now
That's fine.
be under the court. In terms of that, the first case, right, came under the foreigner system. And the tribunal this time gave you a notice to prove your nationality. Right? Where is the question of inquiry
My
under the foreigner? Tell us.
Lordships. Tribunal depend upon the inquiry of the IMDT Act.
No.
On
Thing is
that basis,
is why
Yes,
specific.
should not have gone through it. But since start down,
Inquiry was under the IMDT Act. When the inquiry was under the IMDT.
notice issued on the basis of
Now, just tell
IMDT's
us, that is
lordship,
the
not
reason I'm
subsequent
asking you, where is
notice,
the provision
not
of
no new
inquiry?
case. Here is the lordship find
Kindly tell us.
that
Those
that
things
on the-
which have been done, where IMDT Act is
Lordship.
no longer in force. Since there's a specific provision, it has been converted to. foreign
case
act.
converted.
Now, the proceeding will be under the foreigner. Right? That was the direction given by the effect. Accordingly, notifications were issued. Central government have issued notifications pursuant to which all these matters pending before the foreigner, IMDT tribe converted foreigner tribe, placed before the foreigner tribe, decided by the foreigner. Where is the provisions?
Yeah,
of
here is the
inquiry?
case, Lordship. Tribunal depends upon the inquiry.
Where is under the Foreigners Act? Let us show us any such inquiry under the Foreigners
But should not, but here on the basis of IMDT Act, Lordship, depend, the
That is
first
where
line,
asking
Lordship,
you- That is where asking you, when the IMDT
should
Act is
not-
done, where is the inquiry?
this court also,
Where is the inquiry under the Foreigners Act?
foreigner is no inquiry.
Then,
So
then.
this court should
then
not have
where-
gone
where-
to
where?
the,
Please show us.
no,
We're asking you.
in the Foreigners Act,
When
Lordship,
the IMDT Act.
yes,
is done,
Lordship,
where is
yes, that has
it?
been
Is there any
started.
direction from the Supreme Court that the inquiry which is done under the IMDT Act now should be considered and the proceeding should
No,
be under the
no,
foreigner?
no.
That
that
is not
was
the
not-
direction in the Sarvanda Sonowal.
Notice was
Then tell
issued
us.
on that basis.
No.
Lord's first line,
Notice was issued.
forwarded by Superior Police SP for short Golper under the IMDT Act.
Notice was issued to prove your nationality.
Reference case number 2, expressing doubt. On that case,
Notice
Lordship,
was
there is no
issued to
new
you.
case.
Notice was issued to you, prove your nationality.
On what basis, Lordship, notice?
As required.
Yes, you are suspecting me, Lordship, I am a fraud. On
Yeah.
what basis? That has to be resolved,
Read-
Lordship. There has
read
to be a
the-
ground. There is
read
no
the
ground at
order
all.
to- Read order 2 of the 1964 order. Read order.
If-
Read order.
Yes,
2.
Lordship. But here is the case, whole case depends on the IMDT case, inquiry, everything, if the notice also, Lordship.
Mr. Payak,
Lordship,
Tell us.
Constitution of Tribunals, 64 orders. The central government may by order refer the question as to whether a person is or is not a foreigner with the meaning of the Foreigners Act 1946,
show us any rules under which there
tribunal to
is
be
a
considered
specific
for the purpose of
requirement of
opinion.
inquiry under the Foreigners Act.
In respect of this lordship type, Subordination 1, discussed is that tracking down the IMDT Act, and second also discussed lordship regarding, I have not realized even any subsequent decisions has been rendered by the Honorable Court or this court lordship. I think my learners can do know
That is
whether
where
apart on
asking
this
you,
ground or
can you
not,
show us-
that inquiry is subsequent required or earlier inquiry is required. Here is the case also a sufficient discovery new important. My learner, after this lordship, 2-3 questions I will make reply lordships. Regarding my uncle's death, subsequent by discovery of new important ground. Inquiry officer, subsequent case also, IMDT case inquiry at the 2001. Inquiry officer is saying it is, so there it is an error. Earlier he recorded my father's name Ikram Ali. The same inquiry officer on that year subsequently recorded my father's name Monser Ali. Is it an error, lordship? How can you say it is not an error? And coordinate bench lordships, this honorable court lordships, regarding pleadings of my uncle, that's lordship has seen that WS also stated. And in the lordships, tribunal judgment lordships,
See,
finding is
Mr. Borvia,
lordship. Lordships,
you might have stated in your WS that DW2 is your uncle,
yes, lordship stated,
but what is the finding of the coordinate bench?
but here tribunal lordship, since it is
What
not
is
an
the
appellate
finding?
forum, the
What is the finding? What does the
supervisory
High Court
power.
observe?
lordships,
What is the High Court of?
High Court's order is page lordships
See, what was the finding?
71.
How? what
Yes,
is the-
seven-
whether
71.
DW2 could prove. DW2 could prove
Yes,
that he is the uncle.
paragraph 5, lordship, page 74. We have considered submission of the learned counsel, also perused the records of FT case number so-and-so requisition. On perusal of the written statement, it is seen that there is no whisper that the projected father of the petitioner has one brother by name of Monaruddin, nor there is any pleadings to that effect that the petitioner was the student of SBB Memorial School. The father's name, uncle's name, Your Lordship is fine. In the WS,
Continue. Thereafter.
page 48. Lordship has seen page 48,
We
uncle's
have
name.
seen how you have proved in your.
Yes,
How
yes,
you have proved.
yes, how I, Lordship, page 25. Page 25, exhibit E. Serial number 100, Monorali appeared, Amanatullah. My Sonoddi is my father, Sambhakmar is a mother, Amantullah Sheikh, Amantullah, same family members, Lordship, is they appear along with my father.
What about DW2? What is his name there?
Monorali,
Hmm?
Monoruddin, Lordship.
Where is it, his name?
Page 25, serial number 100.
Hmm.
Who is the DW2?
Hmm.
That is exhibit E.
Hmm.
Page 25. Page 25,
The list of which year?
1979,
1979.
Lordship. I came mainly on subsequent development of this case, Lordship. Your Lordship, the tribunal judgments also find page 68 from bottom, Lordship, 10th, from bottom, Lordships, 8th line, from exhibits, the tribunal's findings. Lordship got it?
Hmm.
Page 68. Page 68 from bottom, 8th line, Lordships. Sorry, 10th line,
Hmm.
from exhibits. And statements of the opposite party, it is appeared that the opposite party was born and brought up at village Singimari under Sarkul Matia in district Gwalpara. She read up to class 5 from SBP Memorial School. After attaining majority, her marriage solemnized with one Kofiluddin Sheikh of village Borbalupara, and accordingly her name is enrolled in the electoral roll of 1997 and 2005. But her name is first recorded in the voter list 1997 as Rohila Khatun. And the year 2005, her name is enrolled as Ohila Khatun, wife of Kofiluddin Sheikh. The opposite party also stated that her parents, Sonoddi and Sonoddin Sheikh, and Chambakman Nasa, whose name enrolled in the electoral roll of 1966, 1970, 1979, 1989 at village Singimari under police Matia in the district Gwalpara. The opposite party is the daughter of Sonoddi Sheikh of village Singimari, which is also proved. Notice that part attained finality. Sonoddi, that part attained
Which
finality.
part attend finally?
Lordships, page 68, from bottom, 10th line, from exhibits.
Yes,
May I read, Lordship,
we
again?
have seen that. Please read.
Yes. From exhibits and statements of the opposite party, it is appeared that the opposite party was born and brought up at village Singimari under Sarkul Matia in this district Gwalpara. She read up to class 5 from SBB Memorial School. After attaining majority, her marriage solemnized with one Kofiluddin Sheikh of village Borbalupara, and accordingly her name is enrolled in the electoral roll of 1997 and 2005. But her name is first recorded in the voter list 1997 as Rohila Khatun. And the year 2005, her name is enrolled as Ohila Khatun, wife of Kofiluddin Sheikh. The opposite party also stated that her parents, Sonoddi alias Sonoddi Sheikh, and Chambok Ban, alias Chambok Ban Nessa, whose name enrolled the electoral roll of 1966, 1970, 1979, and 1989 at village Singimari under Sarkul Matia in the district Gwalpara. The opposite party is the daughter of Sonoddi Sheikh of village Singimari, which is also proved through the school certificate of SBB Memorial HS School. But on perusal of case record, it is seen that name of the father of the opposite party is recorded as late Ikram Ali. I have seen all other information recorded in the reference, which are almost correct and match with the reference case record. In this relation, the opposite party in her WS stated that in the reference case, the name of her father recorded as late Ikram Ali instead of Sonoddi Dewani, but only mentioned in the WS that Ikram Ali is not, her father is not sufficient. The opposite party did not take any initiative, so called for the police report to that effect. So here, Lordship, that on that count, Lordship, tribunal passed opinion against me. This, whether I am the daughter of Sonoddi Dewani or Ikram Ali. And this honorable court, Lordships, again held that since no police report was called, on what basis this court will believe that I am the daughter of the Rohila Khatun is the daughter of Ikram Ali or Sonoddi. In the subsequent development, so I came in the subsequent development, discovery of new important ground, that is order 47, that review can be maintainable. On that ground, I came. And here is the Lordship will find regarding my husband, 19, page 30, 30, Lordship may look into 30, 30. (1997) Bhutan, after my marriage, my name appeared with my husband. There is no dispute that Kofiluddin is my husband. That is page, Lordship's page 31. Will find my name appeared with my husband. I here Rohila Khatun, that was exhibited. And Bhutan list 2005, page 33. Page 33, 2005, 34, my husband's name, my name here appeared is correctly Ohila Khatun. I stated in my WS that Ohila and Rohila is same and one person. But actually, as per school certificate, I am Ohila. That Lordship has find the tribunal only held that since there is no police report was called for whether I am the daughter of Sonoddi Sheikh or not. In the this honorable court also held that incidentally a mistake has been committed that no pleadings at all in my family tree. That was also stated in the judgment of this court. But there is a pleadings, my family tree, grandfathers, fathers, my marital status, life, my children, my brothers, sisters, everything are there. And apart from that, there is subsequent and inquiry report. Lordship put me a question that inquiry was maintainable or not, since everything has been struck down. So that cannot be based on that report, tribunal can proceed. But here is the case, Lordship, tribunal proceeded the case on the basis of that inquiry. And this honorable court also. And subsequent inquiry, Lordship, same inquiry officer, he stated, my father's name is Monser Ali. Earlier he stated, mentioned Ikram Ali, subsequent Monser Ali. So it is an error, Lordship. If there's an error upon the face of that has to be a maintainable order may be recalled, Lordship, on that ground and subsequent development. And nobody denied. I am the, and my other friend also not challenged the findings earlier part. I came on the subsequent development because Ikram Ali. Other part, Lordship, I am not challenged. My learned friends also not challenged my WS, my pleadings, my exhibited documents. It has to be challenged. Now he cannot. This is not appellate forum. This is my humble submission, Lordships, and traditions I pledge, Lordships. All are documented, evidence are there, Lordships.
My lord has pointed out that point, whether the tribunals, my lord, para 83 of the Sobananda Sunwal has said, para 83 of the Sobananda Sunwal, may I read that portion? All cases pending before the tribunals, under the Illegal Migrants Determinants Tribunal Act 1883 cell, stand transferred to the tribunals constituted under the Foreigners Order 1964. So at that time, those cases which were pending, irrespective of the department inquiry was made or not, all cases were transferred to the So the tribunal has got the authority from the judgment of the Sobananda Sunwal of the apex court.
That's not correct.
Yes, the
But we are asking you, inquiry made under the IMDT provision.
yes,
will be applicable.
inquiry made under the IMDT provision. Those
will
are
it be applicable?
yes, those are good or bad. That is not the issue, my lord. Those may not be applicable. Those may not be. Those are not the ground of my lord. Those cannot be the ground of silence here. Those are set aside. But by virtue of the Honorable Apex Court judgment, my lord, order that all the cases, irrespective of my lord, the inquiry was properly made or not, those has to go to the Foreigners Tribunal for finding. So here the question of whether that inquiry was wrong, that cannot come now. That is gone along with the IMDT matter. Because in the next parameter here said in the same manner, same paragraph, it is said, and shall decided in the manner provided in the Foreigners Act, the rules made thereunder, and the procedure prescribed under the Foreigners Tribunal Order 1964. In view of the findings that the competent authority and the screening committee had no authority or jurisdiction to reject the proceedings initiated against any alleged illegal migrants, the orders of rejection passed by such authorities are declared to be void and non-est in the eye of law. It will be open to the authority of the central government or the state government to initiate fresh proceeding under the Foreigners Act against all such persons whose cases were not referred to the Foreigners Tribunal constituted under the IMDT Act, IMDT Tribunal Act, IMDT Act under 1983 by the competent authority, whether or account of recommendation of the screening committee or any other reasons whatsoever. So one way, my lord, even though I accept, my lord, the tribunal has get the authority from this judgment of the Honorable Apex Court to
So there is
proceed.
notification in that regard.
Yes. My lord, notification. Yes,
Yes,
there is a notification. Yes, my lord, there is a notification.
Central government notification.
Yes. Secondly, my lord, the inquiry was in IMDT. Suppose I accept, my lord, there was an inquiry was considered. If my learned senior friend, what he argues, my lord, the inquiry was made during the time of IMDT. In the IMDT, there was a screening committee. Screening committee passed that order, passed that, my lord, the case. Then only it will go to the Foreign Tribunal. At that time, it is not that, my lord, the police will make a reference and hurriedly it will go to the tribunal, my lord. There is a screening committee. Screening committee, all of them, my lord, it was a screen. After screening, only those matters were sent to the Foreigners Tribunal. It is not, my lord, like present days, my lord. I am the present act, my lord. And second, one more thing, just I would like to point out, my lord, as my learned senior friend is, my lord, giving stress on the second opinion. My lord, even this is more, my lord, this will create more problem to the petitioner. What I have submitted already, the finding was against Abdul Aziz. He was son of, my lord, Sonauddin Dewani, Sonauddin Sheikh. And it is his instead of Sonauddin Dewani. Hence, the petitioner prays for police report of the father. Police report is received. But the police report that the name of the father of the opposite party is Sonauddin Sheikh and not Monser Ali. Here again, Monser Ali comes, my lord. It is not Akram Ali. It is not Akram Ali. It is again Monser Ali. Who is this my lord? The Abdul Aziz is the son of Monser Ali. And it is not Sonauddin Sheikh. And now here it is Sonauddin Sheikh. And in the school certificate, it is not Sonauddin Sheikh. It is Sonauddin Dewani. It is Sonauddin Dewani. the school certificate of the petitioner.
One,
And
one.
so now
In the
the-
meantime, disturbing my learned friend lordship regarding another person stated, but actually not. Case number, FT case number is Rohila Khatun. Relative filed a petition. That is the case. My
no,
made a
no, no,
confusion.
that is not, that is not,
Call for the
no,
record.
no,
The
no.
record may
Why
be
should we
available.
call for? This is,
That record
this
is available.
This is
The
relevant.
record is
Your
available.
lordship may go
before
to
the order
the,
of
no,
court.
it is there.
Is fair place, Mr.
It is,
Fact,
you
one
have
relative
placed.
filed the application.
No, no, you go through this, go through the order.
Why you-
I'll go,
Your
I'll go.
case, why
Yes.
should,
That's why I,
state
in
No,
the,
I'll go through the entire opinion. What thereafter says, Sunauddin Sheikh, not Mansur Ali. Therefore, the present opposite party who appeared in the case is hereby released from the case. Is released from the case.
he, no, she.
No, it is the order. He has been released from the case. Under order so and so, he is released from the case and the tribunal direct to issue notice against Rohila Khatun. So this Abdul Aziz is released, directed to issue notice against Rohila Khatun, wife of daughter of Lord Mansur Ali, wife of Kafiluddin, daughter of Mansur Ali, wife of Kafiluddin, of village so and so, foreigners. The process server reported that they are unable to find out Rohila Khatun. Rohila Khatun is unable to trace out, my lord.
Okay. Look
So-
into it.
And therefore, the Rohila Khatun has been declared foreigner.
Notice, see the notice, Rohila,
That's why Rohila Khatun has been declared foreigner.
daughter, he said. Why
Daughter is Monsieur.
Why sleeping daughter of?